give you a spoiler alert, you probably have done a investigation in the past, but asking that question, hey, Billy, did you kick Susie down the slide in elementary school? That is an investigation. The principals have done one, administrators have done one, teachers do one, things like that. So, that is very much a basic investigation. Now, of course, students facing longer suspensions or expulsions have different rights entitled to them under your laws and under the Supreme Court too. But the law adopts the statutory law adopts that too. And then the due process clause might also require investigation, or other laws might in certain circumstances. But those are the big two that sort of came to mind that I wanted to hit on. You might also have a policy that requires an investigation. I don't know about you, but I sit and read, all of my school district's policies every day. I don't know what all is buried in there because I just am reading it end to end constantly. But if it's not required by law, and again, your Title IX policy, it has what is required by law in it, hopefully. If not, come and talk to me later. But if you have another policy that hits on an investigation requirement, or contains an investigation requirement, even if it's not required by law, you need to follow that policy, because the failure to follow that policy could be considered evidence that you're treating that person differently. Why does your policy say that we will do an investigation into a complaint of bullying, for example, but when it's my kid that comes to you with a bullying complaint, you didn't do an investigation? Is it because you don't like the color of my skin or what I said at that school board meeting, my First Amendment protected viewpoints, things like that? These are what I sort of routinely refer to as low-hanging claims, easily debunked if you follow your policy. So I'm going to come back to policy a few times, but make sure if your policy says you're going to do an investigation, you do an investigation. Regardless of whether they're required, investigations provide useful evidence. First, it's useful evidence internally for the school's decision-making process. What are you basing this decision on? What exactly did you find out to decide that you're going to fire somebody or expel a student, or take these major steps? Are you doing it just because somebody complained? Are you okay with that? I mean, is it open and shut, or do you have to do some more thorough investigation, case by case, fact by fact? But they also provide evidence externally, and they provide evidence, one, of your deliberative process. It's evidence of the school's deliberative process, rather, to say, yeah, we didn't do this because we don't like the color of Johnny's skin, or the church that Susie's mom goes to, or the thing that Billy's dad said at the school board meeting. And I'm going to come back to those names, and I'm sorry for everybody whose name I might inadvertently tick off. I try to go generic. I gave a presentation on sexual harassment one time, and I said something along the lines of, hypothetically, suppose that you have a seasonal employee named Oscar. And of course, a man in the back of the room stands up and goes, hypothetically, I am a seasonal employee by this city named Oscar. And I lost a whole hypothetical that day. I had to go back to the drawing board. So I try to stick with generic names. So you'll hear about Billy and Susie and Johnny and Mr. Smith and Mr. Johnson, etc. So again, apologize in advance. The names were picked out of the air, not trying to single anybody out. But in any event, the school's deliberative process for an external organization like the Office for Civil Rights, who enforces Title IX and Section 504 and Title VI, and is looking at those federal anti-discrimination statutes. Same thing with the EEOC if it's an employment investigation. Your investigation is going to be evidence in these types of proceedings and litigation, suing for harassment, saying, no, I didn't fire you because you came out as gay last week. Here is my investigation that shows you pushed a kid down the stairs. I didn't make that up. And these are some obviously extreme examples, but I've seen weirder, I got to tell you, and a good investigation is a good starting place. They also provide evidence that the school responded appropriately to prohibited harassment and other conduct that requires a response. I'm going to break that down into two sections: harassment and then other conduct. Harassment, the standard that the Supreme Court gave us in a case called Davis is the school cannot be, quote, deliberately indifferent to known acts of harassment. That is to say, cannot turn a blind eye to harassment. When I say cannot, I mean legally cannot. Of course, you can do it. You just will be sued and found liable if you are deliberately indifferent to known acts of harassment. And one way for sure to be deliberately indifferent to known acts of harassment is to not do anything. And an investigation can be evidence that you did something. You don't have to agree. If a student comes forward or a staff member comes forward and says they're being discriminated against, and I'll pick something other than sex harassment for a minute, they're being harassed on the basis of race or the basis of disability, and you do an investigation as a school and you come up with that it didn't happen or it doesn't meet the level of harassment, and you go through all of those steps, somebody like the EEOC or OCR is going to look and say, you did what you were supposed to do. The fact that you didn't agree doesn't mean that you're deliberately indifferent. Same thing in court. Now, I say this with assurance. This is if I ran the circus, of course. It is always possible a judge or the OCR or the EEOC might disagree, but this is strong evidence that the school responded appropriately to a known act of harassment. And again, it doesn't have to be, well, we'll get there. An investigation. Thoroughness is another question, or detailedness. And then I mentioned other conduct that requires a response. In this case, I'm thinking about negligence claims. Let's take harassment and unlawful conduct out of it. Let's just say there's some bullying and there's some kids who are fighting, and you find out about it and you don't get to the bottom of what happened. You don't take any inner steps to address it because you don't spend the time to really find out about it. And then somebody gets hurt really seriously again. The students fight again, somebody ends up in the hospital. The school district knew about it, didn't investigate, didn't take any response. That could be evidence of negligence. So saying, no, we investigated. You said there was a threat. Billy, you said that Susie was going to come to school and beat you up. We looked into it, and actually the post was not from Susie, and it was, someone else, or Susie said she didn't mean it. We looked into it. We addressed it. We're not negligent. We're not, we took the steps that a reasonable school district would take. So that's sort of why you want to conduct an investigation in the first place. And I promised hypotheticals, so you're not just listening to me talk for 3 hours. I have a quick one for you. It's not all that quick, I guess. Joan Smith is a parent, and she comes to you during lunch with a screenshot of a Facebook page that she just had printed the screenshot off of her daughter Mary's account. And it's, her daughter Jane's account, rather. It shows a status update from a student named Mary. And this is what it says. I hate math. I hate Mr. Johnson. He's such and Mary's very polite. And so she used, symbols here. He's such an asshole and is only nice to people like Jane Smith, Joan's daughter, because she's hooking up with him. The pictures of them two that Bill showed me at lunch yesterday were just so gross because she's so fat, I could shoot them both. Take a second, absorb what all's going on here. There's a lot of characters. We're going to come back to it. We got Joan Smith, the parent. Jane Smith is the daughter of Joan Smith. Jane, it's the same Jane who is mentioned in Mary's Facebook post. Mr. Johnson is a math teacher, if it wasn't clear. Mr. Johnson is supposedly a jerk and possibly hooking up with Jane, if Mary is to be believed. And Bill has pictures of them. We don't know what kind of pictures yet. And I probably shouldn't have told you that because I was asking a question about that later. And Bill posted some pictures or showed them. And Mary really doesn't like them and could just shoot both Mr. Johnson and Jane. And that's Mr. Johnson and Jane, not Bill. She doesn't seem to have a problem with him. Okay, there's a little bit more. Mary's status was posted from an iPad 30 minutes after the school day ended. And you think it's a district issued iPad. 2 students have liked the status. Another student said that she totally agrees. And a teacher comments. The teacher is, I don't have a name for the teacher. That's a shortcoming on my part. Comment saying, this is inappropriate. We need to talk immediately. Oops. But the teachers commented during his prep period, and his little icon, his little Facebook picture is a picture of him at the beach wearing a swimsuit drinking beer. This is the first time you as the administrator, I see you nodding. Yes, that's what mine looks like too if you find me on Facebook. No, it's not. This is the first you've heard about it. You try to go onto Mary's Facebook page. Privacy settings are set that only her friends can see it. Mrs. Smith said, I need you to do something about this immediately. What do? And what we're going to go through this in greater detail as the evening progresses. But right now, with what I've been talking about with the purpose of the investigation, what do you think the purpose of an investigation into this would be? Do you think you have to conduct an investigation? How many investigations are you going to conduct here? and why might you conduct those investigations? So Russ, if you could send them to breakout rooms, why don't we take, call it 5 minutes, come back at 3:51 or 3:52 to give us time to get to breakout rooms and just talk about the whys. How many investigations, why you might do these investigations. So.
Okay, I'll send you in there. When I click on the button, you're going to see a little thing that pops up that says join breakout room. Please click yes. And it's going to look like you logged off, but really you didn't. Just hold on and you'll get there.
If you don't click yes, you're going to be stuck staring at me, and I'm going to hold pretty still, so you're going to think that I might have frozen, but I haven't. So when we headed to breakout session, I asked, based on this hypothetical, that we have a complaint, or not a complaint, a report by Joan Smith about her daughter Jane seeing a post from Mary talking about Mr. Johnson being a jerk and only being nice to Jane because she's hooking up with him. If it matters, I suppose I should have told you this was high school, but, or, you know, I assumed you assumed. And there were pictures of them, and she's gross and fat. That's what we have here. It seems to have been posted from a district issued iPad. After the end of the school day, we got some other teachers, and students tangentially involved. I asked a few questions, and I hope I remember them. The first one is, how many investigations do you think you're going to be conducting in this one? And I don't know if you voted in breakout rooms to elect somebody just to answer questions, or you all want to shout at once. Either way works for me.
We figured we had between like 6 and 7.
6 and 7. Okay, who are the 6 and 7?
You got to investigate Mary, Jane, the teacher, the possible threat. Then you have the acceptable use policy violation. You have the pictures on Facebook regarding that teacher.
So I want to start and ask, why are you going to investigate Jane? You mentioned that.
Just get more information.
Okay, so I guess Jane's going to be a witness for sure. I just didn't see her as engaged in any wrongdoing. Yeah. So, and I think those are all absolutely spot on. I think you need to. Does anyone else have any different answers? Anyone think there's other people that you'd be investigating, or other investigations need to be conducted? All right. So hearing none, I will go on what I was saying, that I think that's pretty spot on. First, you need to be investigating Mr. Johnson. Is Mr. Johnson a jerk to kids? What's he doing to kids? That's the lesser of the two concerns, of course. But B, is he, quote, hooking up with Jane? You have to investigate Mary. Mary posted this online saying that calling another student gross and fat, and saying she should shoot a teacher and another student. That's a pretty serious thing to post. And whether it's just a threat or whether it's acceptable use against Mary, you could do both, certainly. And then on the second page, you probably want to investigate the other teacher for commenting on a student's Facebook page, if that's prohibited by your policy, or being friends if they could, and that's sort of the hidden fact here, is only friends can click on this. So he's friends with Mary. This teacher is friends with Mary and has commented on it. And he's friends with students, and he has a picture of him in a bathing suit. And I left the description vague, fill in your own imagination there. Drinking beer on the beach, that's the picture he's presenting to students. So yeah, I think so. That's Mr. Johnson, unknown teacher, Mary, for sure. Bill is a question mark in my mind if you want to investigate Bill. Bill is a question mark because it depends on what pictures and who's he showing it to. If you find out that Bill has illicit pictures of Mr. Johnson and Mary, Mr. Johnson and Jane, something that might constitute child pornography, you might need to expand or start a new investigation into Bill to see why he's showing this to people. He has, naughty pictures, and he's showing them of students and of teachers, but students in particular, to other kiddos in your school. So Bill, for me, is an initial subject, but he could be one later. Maybe the student who said she totally agrees, depending on what part she agreed with. If she agrees that Mr. Johnson's a jerk, not a subject of an investigation. But if you find out later that she agrees that somebody should shoot Mr. Johnson and Mary and Jane, rather, yeah, that's maybe something else to investigate separately. It's not its own threat necessarily. but it'll come out and you'll have more information then. So investigations involve is something else to keep in mind. You might have one subject now, or 3 subjects in this case now. And you might add 1 or 2 more later, 1 or 2 might drop out. The other question I asked, not as eloquently as I'll do it now, I'm sure, but is why? Why are you going to do these investigations? What purpose? Obviously, you want to get to the bottom of it, but take a minute and think, what purpose will these investigations serve? So if anyone wants to comment on that.
The first thing that jumps to my mind is the student safety, even though the physical threat is probably just meant in jest or figuratively. I think you got to isolate that student and get to the bottom of the fact that she wants to shoot people.
Sure. So the investigation into the allegation against Mary is for student safety. It's and staff safety. Mr. Johnson and Jane both were possibly the subject of a threat. What about the other ones? And Beth, I think that's you, and you volunteered. So how about the investigation into Mr. Johnson or possibly the other teacher? Why are you investigating them?
Well, obviously for school litigation purposes and child endangerment and legal protection of the school district.
Absolutely. Any other thoughts on why we might do these investigations? And this one, frankly, is sort of a mess. If this, came up, I would expect this would sort of be an all hands on deck one for a school that you have a possible, death threat in today's day and age. And when I first wrote this hypothetical, the first draft of it was probably 10 years ago or so. And actually it was one of my coworkers, not me. When I first stole it from my coworker 10 years ago or so, there were still too many school shootings at that point. But it's more and more every year. That threat, does she mean it? What do we know about Mary? Is Mary depressed? Does Mary have access to guns, et cetera, et cetera? And then the rest of it, you have at least somebody saying there's evidence of a student, quote, hooking up with a teacher. And that could mean a whole lot of things. And I don't know if any of them are possibly appropriate in any school situation. I mean, I can't think of a way to use the word hooking up in a sentence that would make it appropriate to put a teacher and a student in that sentence together. So in any event, that absolutely, it's for litigation. Now there's a wrinkle with this one, that the allegation that Jane and the teacher are, in some kind of physical relationship or sexual relationship or something, that really is a Title IX issue. And we'll talk about Title IX later. So you might have to wait for a complaint on that one. So that one might be required by policy. But the rest of those are for student safety, for protection, and for proving if you do something or don't do something down the road that you did it for protection in that litigation. So the next thing I want to talk about is sort of the solid foundation, the start of an investigation. And the first thing is documentation. If you've heard me talk before, you know that I will say, A, that as a lawyer, I have to hate trees. And B, I want documentation in all things. Your school defense lawyer will thank you for really 2 things in every situation: for planning ahead and writing things down. And that's what this part of the presentation is about, planning ahead and writing things down. So first, document the discovery. Assuming it's a staff member, the staff member who discovers the alleged misconduct should create a written statement. Now, oral statements can be taken for Title IX and for other required harassment reporting things, but should have a written statement that describes everything that person knows about the conduct, including the names of potential witnesses, the identity of the alleged wrongdoer, if known, and the date the misconduct occurred or was discovered, and anything else that's relevant. And I just have 2 quick hypotheticals. You don't need to go to a breakout room for this. This is just, one. If I tell you I'm a teacher, I'm, not a math teacher, so I'm picking on them today, but I'm a teacher in your building, and I say, I saw a kid in a blue hoodie push a girl in a white sweater today, and she fell down and it looked pretty bad. What are you going to do with that? Okay, you're going to go look at surveillance footage, see who's wearing a blue hoodie or in a white sweater. I didn't tell you the time. I didn't tell you the kids. I didn't tell you where in the building, or if it was in the building. Was it on the playground? Was it getting off the bus? Okay, good luck, administrator. That's what I got. My job here is done. Well, hold on. Wait a minute. But conversely, hey, I saw, Billy and Susie having a fight today, and Susie punched Billy. And it was about, 15 minutes ago, and it was outside of the bathroom. And Susie, fell over, or Billy fell over. Can you still see my PowerPoint, everybody? My monitor's giving me some grief. That's much easier to investigate. And then, of course, the documentation is always going to be, thank you, always going to be an exhibit or potentially exhibit. So documentation, and then what kind of reports need to be made. You can report suspected crime. I'm going to talk about law enforcement in detail later, but report a suspected crime to law enforcement. If it's not an administrator that found the conduct, call the administrator, report it to the appropriate administrator if necessary, and sort of follow through on that to get the ball rolling. And if it's like Title IX, for example, has to go to the Title IX coordinator at some point for processing. So if it's about sex harassment or possible sex harassment, take it to the Title IX coordinator. What mandated reports need to be made depending on the situation, who's involved. And detailed reporting, again, is critical. It doesn't need to be a book. It can certainly be typed. It can be handwritten too, but notes something that says you did it, because I mentioned earlier that an investigation is evidence, but if it's not written down, it's not evidence. And more and more today, hearing officers in courts and investigators are saying, write it down or it didn't happen. Okay, that's great that you're telling me that you responded and you went and contacted the principal and said that, Susie had pushed Billy and Billy, went to the nurse's office. Where's the record? Where's your nurse's office record of that? Where's your report to the principal? Show me. So that is, sort of some big first steps. But then we want to talk about, I'm sorry, not quite yet. I want to talk about whether any, and I say further investigation is necessary. I said earlier, you probably have conducted an investigation, even if you didn't know it. If you asked, hey, Billy, did you push Susie down the slide? That's an investigation. And what might mean you need a further investigation, a detailed investigation, an investigation with a capital I. First of all, do you have enough information based on what you've seen? Do you need to actually go and interview people or go and review more evidence? Or, did it happen right in front of you as the principal or superintendent or other administrator? Okay, that's one consideration. And of course, is the behavior complained of violate law or your policy? That's something else to look at. Obviously, if yes, it probably weighs in favor of you need more of an investigation. I think Billy was cheating in class. That violates a policy, but that's requires a different level of investigation than, Billy sexually assaulted somebody in the bathroom. That requires a very intense investigation. Same thing, it's required by policy. Does the conduct in question involve a pattern of prohibited behavior? Could the conduct result in liability for the district or the school? Did the alleged wrongdoer admit to it? Hey, I just saw you push Susie. Yeah, that was me. I'm mad. Okay, you don't need to go interview 10 people that were gathered around. Billy admitted it in that case. Is the investigation likely to yield something that will be useful in an educational decision-making process? Not just discipline, but I'm thinking about students with special education needs for a minute here, where bullying can be a deprivation of FAPE, and bullying directed at a special education student could also be considered harassment on the basis of disability. And in both of those cases, a question for the student's IEP team or 504 team is, does the student need additional services to respond to, or if the student is the alleged bully, to not engage in bullying behavior? So even if you kind of know it pretty well, is an investigation going to help you get information to feed to an IEP team or a 504 team to talk about where do we go from here? Or, of course, it goes to student discipline issues too. So one just quick word on this, even if it's an allegation against an employee who's no longer an employee, or a student who has graduated or withdrawn or something like that, you might still need to conduct the investigation depending on the circumstances. Now, it could be a logistical problem and it could be truncated because the former employee or former student rather, they're both still people, I should have spoken more clearly, won't want to talk to you necessarily, and you can't make them talk anymore. So that is, some complications, but, I want to stress that you might still have that obligation. Now here I have just a few sort of horror stories / war stories that sort of illustrate some of these points and why this action is appropriate. I'll save one till the end, but the former employee makes me think, I had a complaint once against a teacher in a school district who was told that the school district was told that this teacher was having a sexual relationship with a student. And the complaint was made by a former employee who's now living out of state. So I was the investigator. I was kind of a new lawyer at the time. I called the complainant. She gave me her story. She knows the teacher. She used to work with this teacher. She knows the student. It's a small town. They're all friends. She's been over at the student's house and, has seen them coming, downstairs or something like that. Just, okay, pretty, serious details. I go through the investigation. He denies it. The younger student denies it. And then the complainant calls me and says that she doesn't want to talk to me anymore for reasons she doesn't want to get into. And B, she recants her statement in its entirety and says that I was wrong. It was actually this student's older sister who is, our age or older and is not a student at the time, and nothing wrong ever happened between the two of them. I wish that complainant had been an employee and I could have directed her to, answer questions and had a little more leverage over it, because I later found out after the investigation was dropped due to total lack of evidence, or it wasn't dropped, I concluded due to total lack of evidence, it had to be dismissed. No evidence, everybody denied misconduct. My complainant recanted the story of misconduct. And while it didn't involve this student, I later found out that this teacher at this school was arrested and convicted of having sex with a different young lady student. So there was something going on, and I'm never going to say that the complainant lied to me, perhaps got it wrong, but I wish I'd have been able to ask some more detailed questions. So there is some logistical issue there. I'm going to save the other story for the sort of the end of this section before I send you to breakouts again. Because the next thing is there may be some interim steps that are required. And again, Title IX requires interim steps, interim supportive measures, it's called, while the investigation's pending, counseling, things like that. And I don't want to spend the whole day talking about Title IX, but that's just something to keep in mind. But the first kind of interim step is, do you need to put the employee out on leave? Don't send him there. He looks like he has too much fun. But do you need to put an employee out on leave pending an investigation? And the answer is maybe, or probably in my mind. Depends on the nature of the alleged misconduct, the employee's duties, and the duration of the investigation. And there's several other factors to look at. Does the employee have the ability to destroy relevant evidence? If you're doing an investigation into, say, your IT director, and the investigation is about, child pornography or, dirty messages being sent on the computer or something like that, maybe you want to lock your IT director out before you start the investigation. Just going to throw it out there. Does a secret investigation, is it more likely to get more relevant evidence, adduce more relevant evidence? If I don't know that something's coming, am I going to be more honest in my response to it? Maybe. If putting the employee on administrative leave is necessary to protect the safety of students and staff, going back to our allegation against Mr. Johnson for a minute. Gosh, if he is having a sexual relationship with a student, maybe you don't want him in your school right now for liability reasons and student safety reasons. You think about student safety, I'll think about liability, and we'll be on the same page probably. Same thing, whether putting the employee on administrative leave is necessary for liability. So you might want to issue, if you do place an employee on leave, you still have the ability to direct the employee because they haven't fired him. You've just put him out on leave while you're looking into it. And you can give specific directives like not coming on to your property during the investigation except for the interview, not doing any work for you, turning in all of your property, their keys, their computer, things like that, and telling them to not access any of your electronic records, things like that. So it's just something to keep in mind. There are other intermediate steps, interventions. I talked about Title IX, but interventions might also be necessary to protect student safety. If you see two students fighting in the hall, you're not going to go, well, I'll investigate this later and walk away. You're going to stop and say, at least say, knock it off, right? Teachers and staff and administrators are going to do something. So the appropriate intermediate steps, again, to protect liability. And then there may be, again, some special considerations for students with disabilities in here. What immediate steps? Is this something you're going to report to an IEP team? Is it something the case manager needs to look at? I don't know, but just keeping that lens in mind, if this is an investigation that involves an allegation to or by a student, or against or by a student rather, with a disability, you're going to look at it. Act now is my last piece of sort of preliminary advice here. If you decide to conduct an investigation, even a minimal delay might result in the loss of evidence or potential exposure to liability, or give the employee a chance to cover it up, right? Employee, I say, or student, the alleged wrongdoer. And depends on the specific allegation, there might be a risk of student harm too. Delaying on the investigation to Mary earlier about wanting to shoot Jane and Mr. Johnson, okay, well, we'll get to that in a week or so. It gives gives Mary rather a week or so to show up to school with her parents' gun if she has one. So that's one hypothetical. I have another actual not so hypothetical war story. It's a school I represent. It ends up with a parent complaint to OCR. That's sort of the punchline. But a student comes to a dean, let's say, analogous to a dean position, and says that another student harassed her, says that, we'll call him Billy for the sake of this, Billy groped her. And then a couple other girls come forward and say kind of the same thing. And the dean, for whatever reason, didn't get around to looking into it. The dean was sick, then the students were out on an extended experiential learning project and didn't come into the school. And then the student was sick, and this was in, say, September-ish, and it rolls around to November. And at this point, a large number of female students come to the principal and say Billy groped them, including the first 3 students who made the complaint. It ends up at 10 students. 10 students accused Billy of groping them, and 7 of them were in the months following the initial complaint. This case ends in federal litigation by Billy, and then it ends up also in a complaint, John Doe will say, his name isn't Billy, of course, I wouldn't tell you that. And then it ends up with a complaint brought on behalf of the girls to the Office for Civil Rights. And it wasn't a parent of any of the girls who complained, it was a parent of another child who heard about it, but had strong feelings about sexual harassment and a past of sexual abuse, we believe, who complained to OCR. There is an opinion, or there's a consent decree on OCR's website involving this school, and it's very brutal. While the school denies wrongdoing and they just agreed to some monitoring, the consent decree says, we're not saying that you were deliberately indifferent, but we're saying at this point the evidence looks like you were deliberately indifferent. And this is because a teacher had other things come up. I know the administrators there, they wouldn't have sat on this, and they didn't say anything. As soon as they found out about it, they acted promptly, but they didn't find out about it till later. So a delay, even at that initial reporting, can lead to some pretty negative publicity, B, a pretty unsafe situation. I mean, there were protests at this school. It was a bad situation. It also, like I said, ended up in federal litigation by the male student, saying his procedural rights were violated. And that's where I learned about the Goss case I mentioned earlier. And no, his procedural rights were not violated. Thank you very much. Thank you to the court for agreeing with me too. So that case was dismissed. But in any event, this was something that promptness on behalf of one employee could have prevented, federal litigation, OCR complaint, negative publicity, protests in the street around the school, that kind of thing. One other story about acting promptly and reporting. This is another not so hypothetical, happier ending. The school ends up winning on this one on all grounds, but a student of color in a small town with not a lot of students of color in it has another friend, and they're like 2 of the only 4 students of color in the school, who they refer to each other by a certain racial slur periodically in the halls, and they're okay with it because it's what they call each other. But they have another friend who is not a student of color who wants to be in on the side talk and thinks it's okay for him to use this racial slur, and nobody should be using a racial slur in school. I'm not saying that at all, but the children did not object when it was just them calling each other the racial slur. But when this outsider, who was still a friend of theirs, did it, it became a problem. And it goes something like this. call them Billy and Johnny, Billy being the student of color. In classroom, first hour, Johnny calls Billy the racial slur. The teacher says, hey, knock it off, doesn't tell the principal, despite a policy that says, if you hear something that might be harassment on the basis of race, you'll tell the principal. Okay, knock it off. I don't want to hear that. You know, you can't talk like that. They're in the same class, third hour. This was high school again. And Johnny calls Billy the same racial slur. The teacher says, hey, knock it off. I don't want you to hear, you know, you can't talk like that. Repeat this pattern. I'll save some time. Repeat this pattern throughout the day, 4 or 5 times throughout the day, 2 or 3 days a week. Principal never finds out about it. Kid's been called this particular racial slur 50 times in the course of 2-week period, something like that. No action taken by the school because the school doesn't know about it. Now, again, the school responds promptly when they find out about it. They investigate, they discipline the student for saying this racial slur over and over again. They find out that Billy and his other friend call each other the racial slur, and they discipline them too, because nobody gets to use this racial slur in the school. It's, you know, not a word we use in our school or in any school. I think beating around the bush, you all know the one I'm referring to. So, you know, you cannot use it in school. And OCR eventually, after I don't know, year and a half, I think. No, it was 2 different investigations, and the latter one lasted over a year and a half. You know, dismissed all the charges because the school, when it found out, acted promptly and responded appropriately. So again, consistency in your policies, prompt response when you're aware of it. Investigation was evidence in that case. Immediate interventions. They had school-wide assemblies on not using racial slurs later, you know, not immediately afterward, but long enough that OCR, soon enough rather, OCR could see it. Training to kids, things like that. I think it was grade specific, not school-wide. But anyway, things like that. That's all sign of a good response. That was good evidence. It made this child's, you know, educational environment more welcoming, certainly, and it protected the school against possibly costly liability, although it did have a sort of a 2-year OCR complaint. Okay, with that, I'm going to go back to our earlier hypothetical for just a minute. I think we can do maybe 3 minutes in this breakout room. Going back to Jane and Mary and all them, what kind of immediate steps might you want to take in that sort of nightmare hypothetical I said earlier? So Russ, if you can send them away for a minute, we'll come back and we'll talk about immediate steps the school might want to take.
They should be on their way.
Yep, I see people disappearing. I'm guessing it's still fairly light where you are. It's starting to get dark here. My lighting's going to look weird in a minute.
Oh,
It's definitely getting a little bit darker, but it's still
Yeah.
pretty light. I went for a walk here a little while ago, just to
Nice.
get out of the house before I wanted to, I don't know, go crazy.
Sure.
It was pretty nice. We're supposed to get snow tonight though.
Yeah, us too. 3 to 6 inches tomorrow, I think, in my area, and the sky is promising every inch of that from what it looks like.
Oh, really?
Yeah, so
We're
that's
supposed to get 2 to 4.
okay. Well, it's enough going in the weekend, get my kids something to go sledding on, so I'll take it.
Yeah. As long as it's warm enough to go sledding. We're tired of the 20 below stuff.
Yeah, I'm trying to convince my parents to move up here from Detroit because, you know, grandkids are here and it's expensive to fly to Detroit a few times a year, so, or here. And, you know, he had me talking about house hunting, and then he goes, well, yeah, but the weather says it's 20 below in Minneapolis today. I don't want to move to 20 below. It gets 20 below in Michigan too, just not as often, you know?
Yeah.
And they're retired. They don't have to go outside.
Yeah.
You know?
Michigan has more humidity too, doesn't it? So
Yeah, more
It
snow,
feels
but
colder.
warmer. Yeah,
Yeah.
well, yeah. I remember when I was right after I moved out here, I remember my mom who worked in schools telling me that the school district had to close because it was 40 below with wind chill and the buses wouldn't start. And I remember thinking that sounded really cold. And then after a few winters here, I'm like, my schools stay open when it's 40 below with wind chill. If it gets to 40 below actual, we're talking school closure. But
Yeah, it's funny because people think like the wind makes a difference to inanimate objects. It does not.
nope, that bus will run. Your kiddos
It
are
will
freezing at the
still run.
stop, but
Take one for your sister too.
How about 2 for me and 2 for Olivia?
How about we bring him back? I said 4:20.
Okay, here they come.
Okay, have fun.
All right. I think we got people coming back. Welcome back, everyone. We're here for another hour of Minnesota's Greatest Hits, continuous music. No, wait, sorry, that's my other job. No, just kidding. The headset's giving me a power trip. What immediate steps do we think the school might need to take in response to that first hypothetical that we talked about?
The safety issue, you have to investigate if that's a legitimate threat.
Investigate Mary as the legitimate threat. Yep, jump right on that one. Call the police, possibly. All of those things. Any other issues that require immediate addressing, and how would you address them?
We talked about the teacher and possible relationship with the student. So possibly putting that teacher on leave and investigating immediately.
I think so. I think putting the teacher on leave and investigating immediately is a good step there. Anything else?
We talked about possibly putting both teachers on paid leave pending investigation. If we had a policy regarding teacher-student relationships on social media. And if there wasn't a policy, possibly even still moving forward with the leave, if the picture was highly inappropriate, we would need to see the picture.
Depends on the swimsuit. I gotcha.
And to me, it's
Hey,
not.
Christian, I get this question a lot where people ask if they should do paid or unpaid leave. What's your recommendation?
Well, do you have a contract? Do you have something, a policy in place that talks about it? You know, an unpaid leave is essentially a suspension, and it could be argued that that's discipline before the result of the investigation. So you could end up looking maybe at a due process claim if the employee has a property interest. You know, it sort of all depends on the unique situation. In Minnesota, it's a much cleaner question. All of our teachers and staff members tend to be unionized, and they tend to have arbitration as a recourse, and arbitrators say that's double jeopardy. You suspended the guy before you investigated, so you can't turn around and fire him. And you have a much easier hurdle there, but it's still keep that double jeopardy thought in mind. If a court looks at it or something, you know, are you just dogpiling at that point? So paid administrative leave is safer, fewer concerns, but you might not have to do it. Dr. Peters, I think you were going to comment on something else.
Yeah, the fact that the picture keeps coming up about that teacher, you know, sitting on the beach with a beer in his banana hammock and so on. To me, it really isn't the picture. It's the fact that he's a friend with that student on social media. That is what crosses the line in my eyes. You have to accept a friend request. We're not friends with our students. We're friendly, but we're not their friend.
And just one more time for the record, I did not supply the kind of swimsuit that the teacher's picture contained, but that would certainly raise an issue there. Yeah, I think these are all good thoughts. There's one more I'm just fishing. Does anyone else have something we haven't covered yet before I sort of put my 2 cents in? All right. So first of all, any police reports that need to be made, certainly with regard to Mary, you know, report a threat to the police. You don't want to be on the news for that at all, certainly for any number of reasons. And of course, you know, that needs to be dealt with. Getting the teacher, Mr. Johnson, out there first, and was another step after, you know, it was my second step after you call the police and have Mary, you know, have a conversation with Mary, maybe over the phone, saying because you can suspend Mary pending the investigation for the threat, just how long the suspension is without any worries. So yeah, jumping right on that. The second thing on my list would be getting Mr. Johnson out of school, because there are cases where, you know, schools find out something about a teacher. The teacher is engaged in some kind of sexually inappropriate relationship with a student, or is, you know, made a pass at a student, or whatever it may be. And if the teacher comes back, after that allegation before the end of the investigation, the school is more likely to be, and almost invariably will be, liable if something else happens in school. If, you know, if Mary you find out about Mary's comment that Jane and Mr. Johnson are hooking up, and the next day they hook up in the the math room. You knew about it and you could have prevented it, and you didn't, and that's much greater potential liability. The cases where schools tend to win on these kinds of claims are, you found out about it, he was immediately placed on leave, or she was immediately placed on leave, didn't see the student again if there was anything to it, and was subsequently fired. So absolutely, I'd get that teacher out. The teacher who made the comment on Facebook, I'm actually a little less concerned with. I'm all for putting that teacher out on leave, but it's less of a safety concern. He's blurred a boundary, but what he said on Facebook was, hey, this is inappropriate and we need to talk about it. He didn't say, yeah, Jane's a hottie, or yeah, Mr. Johnson sucks and we should shoot him. He didn't say anything like that. He seemed to have a professional response. Did he blur a line or cross a line or blur a boundary? Absolutely. I don't know that he poses an immediate risk, but putting him out on leave would make sense too. One thing that sort of an Easter egg of things to come is nobody mentioned Bill, the guy who has the pictures. I'd go talk to Bill really quickly. He'd be maybe my first stop. I'm not sure I would, I wouldn't do a formal interview yet. I would just ask him, depending on how old he is and your rapport with him and all that. Hey, I heard you have some pictures on your phone of Jane or Mr. Johnson. Can I have them? Or what, whatever approach you would use to get Bill to maybe give them to you, or calling Bill's mom or dad and asking for him, whatever the best avenue is with that particular kiddo, because those are going to be sort of some key things. And maybe it's incriminating against Bill. Maybe Bill gets in trouble for having and sharing, Jane's naked pictures or whatever, but you need to know what that evidence is, and pictures on a cell phone can go away like that. So especially if they're Snapchat and designed to go away like that. So if there's a way to get your hands on them kind of quickly to preserve them, that would be, a good thing. Okay. So we've been talking about the investigation, and my notes say, what exactly does a school investigation look like anyway? So some common investigation procedures, they all sort of follow the same thing, but the first thing I want to talk about is that initial scope of the investigation. What are you going to do? What are you looking into? And the reason this question should be asked up front is it frames the rest of the investigation. I'm looking at this sort of nightmare hypothetical I gave you, and we've asked what, my first question was how many investigations and why. Coming back to that, now that's the scope of your investigation. That's what you're looking into. That's what your questions are going to be based on. That's what your evidence you're looking for is going to be based on. So if a scope is dictated by a law or by policy, that is the scope of the investigation. For example, in a Title IX complaint, the scope of the investigation is limited to the formal complaint. You might find out about all kinds of other stuff in the course of a Title IX complaint, but the investigation has got to be limited to that initial complaint. Not so for more, sort of common law or just policy driven or just good idea investigations. A bullying complaint, okay, I'm talking about an incident at recess where Susie pushed Billy, but now I want to hear about all these other times that, Johnny and Jack pushed Billy and how Billy is just being bullied. Okay, great. We can build on that and expand the scope. So the scope might change. Billy and Bill have no relationship, by the way, to my hypothetical Bill. So you might gather other information in that. Okay, and then back to that question, what are you hoping to learn through this interview? That's the why question from earlier, just reframed. What evidence do you need to complete the investigation? You want to think about that up front, and maybe, depending on the severity of the incident and the size of the investigation, that might be 2 seconds worth of thought. I need to know if Billy pushed Susie down the slide at an elementary school. Okay, that's going to be easy. I don't need to write my questions out for that. I know what I'm going to do. I'm going to talk to the playground monitor. I'm going to look at the security camera if we have one. I'm going to ask Susie what happened. I'm going to ask Johnny who was standing there what happened, and then I'm going to ask Billy what happened. I might just ask the whole group depending on who I am and where this is. But that's just kind of instinctive, and you do it. More complex situations like the one we've been talking about, you want to sit and think, what do I need to know? I know why I need to know it, but now what specifically do I need to know? I need to know, for our case with Mary and Bill and Jane and Mr. Johnson, I need to know what Jane and Mr. Johnson's relationship is. And to get there, I need to know what's on Bill's phone. I need to know if Bill is engaged in some kind of, harassment or improper conduct, sharing pictures, depending on what the pictures are. And even if he's just sitting there gossiping about Jane being gross and, it has nothing to do with sex. The pictures are just Jane, in a sweater and Mary thinks Jane looks fat, whatever it may be, you need to know what that is. You need to know when that post was posted. Was it posted? It looks like it was posted 30 minutes after the end of the school day. You need to know if it was posted with your iPad to say if you have an acceptable use policy. You need to know why the unknown teacher and Mary are friends. Maybe they're relatives. Maybe there's nothing there. It's their stepdad. We don't know yet. You got to, look into it. What's going on? Maybe not. Maybe, he just doesn't follow the procedure and is friends with students. But, those are the things you need to know. And that sort of drives the bus, as it were, as to what the investigation is. And then some initial investigation strategy after you have an idea. And again, you might not need to think strategy in every investigation, but you might need to stop and think. And the first question that I ask is an investigation is, who is our investigator? Is it an internal or an external investigation? And of course, I don't want to overly urge you to use an external investigator because I'm not here to market at you. Yes, I do investigations for clients with some regularity, but that's not what I'm here to say. When you think about whether you need an internal or an external investigator, there are a lot of questions that you want to consider. First of all, the potential ramification of the problem, both practical and legal. And frankly, your ability of the staff who would normally do it to, in your opinion, do a thorough job, right? Whether an internal investigator would be viewed as biased because of their position in the school or past relationship with the complainant or the respondent. I know 9 times out of 10, an investigator is a principal, just quick, did you push Billy down the slide, that kind of thing. It might be 99 times out of 100. But if we're talking about a kiddo who is facing expulsion for sexual harassment or for, some big ticket item and an assault, and that principal has given that kiddo, 50 days of detention over the last few years, or has suspended them at 6 or 7 times, and the parent has said, you suspend my kid at the drop of a hat, it's because you're racist or because you hate my kid. Do you really want that principal doing the investigation? That principal might do a bang up job. That principal might be a secret ex-FBI agent who's done investigations for 35 years. They probably are qualified. Do you really want that person doing it with that kind of appearance of impropriety or that immediate argument the parent's going to make? I don't know. I don't think so. Maybe another administrator, but maybe the parent really hates the district and will say that everybody there is a bigot. Maybe you go with an external investigator at that point. The long-term impact of using an internal investigator, including future relationship between the investigator and the subject of the investigation. I'm going to pick on a special ed student for a minute here. Let's say there's an allegation about a special ed student assaulting someone. Or there's an allegation, well, I'll fill in the or in a minute. And this is a new high school student, 9th grade, going to be there through graduation and probably transition services. So we've got between 4 and 7 years of more dealing with this family. The family has been maybe problematic or difficult to deal with, earlier. Do you really want that principal's, say, first experience with this kiddo to investigate the student for this assault? And then you got to deal with this family for another 7 years. I mean, maybe not. It all depends on the relationship, right? The other one, I've been talking about students for a minute, but going back to employees, do you really want this, this employee who might be a long-term employee or either long-term, got a great career ahead of them, or long-term, she's been there for a long time. What's the long-term impact of that person's boss investigating him? Maybe nothing, maybe something, just something to keep in mind. I mentioned earlier, can your internal investigator conduct the investigation in a thorough, objective, and timely manner? They might have all the skills to do the investigation, but just be busy, right? You got a whole school to run if you're a principal. You got a whole district to run if you're a superintendent. Deans have other stuff to do too, and depending on how many of these things are there, could you have somebody get these things done? The school I mentioned earlier that had the OCR complaint in the federal litigation, they eventually hired somebody to be more or less a full-time investigator. And they also proctor standardized tests, I think, and they still come back and need external investigation sometimes because of the scope or complexity of one. So that particular school has a lot of investigations, had a lot of investigations. And then the likelihood of the investigator having to testify at some kind of administrative proceeding or litigation or other matter relating to the investigation or subsequent, action or discipline relating to the investigation. If you know this one's going somewhere, this is a family that sues at a drop of a hat, this is an employee who sues the drop of a hat, or they've already said they're going to the EEOC with other things, do you want your internal investigator to have to go through that? Or do you think they'll do a good job doing it? And, you can have an external investigator, you can not have an external investigator. I know you have staff who are able to do the investigations, but just something to think about, both A, for potential liability, and B, for just sort of quality of life for everybody involved in the district. So just something to keep in mind there. All right, I talked about scope, strategy, and sort of procedure. Most investigations follow the same pattern. That guy, by the way, is my favorite detective, just random trench coat guy with a magnifying glass. The investigation usually looks like something like this. You receive a complaint and or an allegation, and then if there's some procedural work, Title IX requires some procedural work. Otherwise, there's an interview of the complainant, or the complainant gives a statement in writing if they don't want to be interviewed. Then you review documentary evidence, surveillance footage, whatever. You gather that and look at it, because that also forms into the questions you're going to be asking. Then you interview fact witnesses. And after that, you digest all of it, you interview the wrongdoer. This might be over the course of a day, it might be the course of several days, might be over the course of several weeks, depending on how involved it is. That's the usual pattern, though. At each stage of the process, your investigator should reevaluate whether additional investigation is warranted, either going off in a new direction or there's a new witness who is identified, and who should be interviewed next, whether it's, sort of that pattern we talked about, or, like I said, somebody else additional. So, going back to the hypothetical, we have 2 students who clicked like on that, plus the student who commented she totally agrees. You want to interview those kiddos. They're fact witnesses. Why did you click on this? What do you know? Why do you totally agree? Did Mr. Johnson try to hook up with you? Or are you just saying that you think that Jane's fat and gross? Whatever it is, you want to interview those people probably after you interview the complainant. And in that case, the complainant, depending on which investigation we're talking about, is either Jane making her complaint against Mary, or Jane's mom making a complaint against Mr. Johnson. So, and then Jane is a fact witness in one of those. She might be interviewed 4 or 5 times in the course of this. And then, the interview into the teacher that commented, you find out, you're going to look at his, we'll talk about looking at Facebook later, but you find out that he's got other friends on Facebook. You're going to want to, who are students, you're going to want to talk to all those people and sort of constantly reevaluating who's next, usually with the goal of the subject being at the end. And the subject interview at the end is there because that's your chance to sort of lay out the evidence and get sort of meaningful answers to your questions. You don't necessarily only get one shot, but you only get one good shot. And going into it knowing that, you're not related to the student whose post you clicked on, and knowing from other people that picture was taken of you while you were hammered on spring break, and that by the way, from documentary evidence, that that there's this acceptable use policy, and you've signed off that you won't be Facebook friends. And, gosh, I found this old reprimand from a few years ago where we warned you once not to be friends with students. You want to have all of that stuff in your hand so you can go and ask unknown teacher about this and see, hey, didn't you know that you weren't supposed to do this? And, what kind of message do you think you're sending? And, all of that kind of stuff. And if there are any other pictures or comments that come up, you want to have those too. And again, it's for efficiency. It's because you get one good shot to make a good impression, to your best shot at getting an honest answer and sort of pushing to the outcome. But it's also, again, that quality of life. So you're not spending forever doing this and running down every lead. So, reviewing that potentially relevant evidence, looking at that, seeing what's going on next. Who should you be interviewing? I said fact witnesses. Who are the fact witnesses? It's obviously different in every case. Does the complainant identify someone? Did the complainant say, oh yeah, Johnny and Jack saw Billy push Susie? Or, okay, they're probably fact witnesses. Does the complaint leave out individuals who might be important to this investigation? Do you know that, Jane has a sister that she tells everything to, or a best friend who she's inseparable with, but they don't mention that. Is that somebody that you need to be talking to? Who was present for the alleged misconduct? Can you see it on a surveillance camera or something? Or do you just know if if something took place in math class, if there's a fight in math class, who's in math class that day, you have attendance records. You might not need to talk to all of these people, but you want to have an idea of who the sort of the realm of people you want to talk to are. I think that worked. Who received the initial complaint? The staff member that gets the initial complaint is a witness, unless they're also the investigator, which gets, then they just put their ideas down too. But the staff member who gets that initial complaint, if Jane comes in sobbing because she saw this, that's way different than if Jane's mom, is the hypo I gave you, comes in and is mad about Mary posting this. Jane comes in sobbing. It's not true. I've never hooked up with Mr. Johnson. She's just mad that I get math, better grades in math class. Maybe, the investigation looks a lot different, but that all depends on that initial staff person. Who can provide necessary background information? That's if it's an investigation to a student who's had multiple similar incidents, maybe the past teacher, things like that. Is it even necessary to interview students is a question. I recommend, I said earlier, documenting things and planning ahead. We're going to talk about planning ahead. And one of the things I want to plan ahead on is who is going to be present for your interviews. Are you just going to walk into a room and do it yourself? You might want to have more than one representative of the school. You might want to have more than one administrator, or possibly you might want to record. It depends. If you have an employee who's in a union, I don't know if you do, they might have rights under a case called Weingarten to have a union rep there. Under Title IX, you can have a representative. It's a U.S. Supreme Court case. Under Title IX, you can have a representative there if you're a party. So who has a right to be there, and who are you going to let be there? In the ordinary course of business, a student doesn't have the right to have their parents sit on an interview. And if the investigation involves students, you want to determine ahead of time, either as a district sort of policy or procedure, or the investigator determines ahead of time whether parents will be permitted to attend the interview. And you want to look at factors like the age of the student, the subject matter of the investigation. And unless, again, you've adopted a policy to the contrary, you're not required to permit parents to attend the interview, except for Title IX, where the student has a right to have an advisor there. But that's only if they're a party. Witnesses don't. The complainant and the respondent do. So honestly, I've done this both ways as an investigator. It all depends on what the district wants for having students there. So I had one investigation where just no, parents can't be there. You can interview them afterwards. If they want to give you their 2 cents on the situation, you can interview them as witnesses, but they can't sit through their student's interview because they're going to coach the students too much. And I have had certainly districts who didn't care so much about the coaching and said, absolutely, we let the parents sit in. And the investigator has to give it all the weight that it's due. I had one case years and years ago, and I didn't write this one out, I'm just remembering it now, where a student alleged that she saw inappropriate material on her teacher's computer. The teacher, sort of turned the screen away really quickly, and it was some kind of dating website, Sugar Daddy or Sugar Sweetie or Sugar Cupid or Sugar Heart or something like that. And the parent essentially spoon-fed answers to the student when I was interviewing the student. Oh, go on, tell them about how you saw the lady's, quote, top privates. I'll remember that on the website. This was a 8th grader or a 9th grader, I think. I think maybe could have used different words, but whatever. Just go on, tell them about, how we pulled the screen away. She kept just having the student reiterate what was in the complaint. The investigator has to give that due weight. And I warned the parent, and I do every time a parent answers questions or tries to, that, I'm here to get your child's firsthand view of it, and you telling your child what it is not your child's firsthand view. I will give that the weight that it's due. And if you ask me what that weight is, it's not very much. So I want to hear your kiddo's account. If you have something you want to tell me afterward, that's fine. And some parents just sort of run roughshod over that and want to put their version in right away. Some parents sort of, are quiet afterwards. Sometimes it's a mixed bag. So it really depends. And I've had I've had investigations that have gone really well with parent involvement. I'm not here to, downplay the role of a parent or anything like that. So it all just kind of depends on what you and your investigator are comfortable with. So just something to keep in mind. And certainly if it's law enforcement, whether law enforcement lets parents in is a different matter if they're involved. I certainly, think it's a nice thing to tell parents that you're interviewing their child. But again, if a parent says you absolutely have no right or ability to interview my kid, really, show me the case, show me the statute. I sure do. They're here right now. I'm talking to them. They say hi, click. No, maybe don't go that far. I get a little antagonistic at 4:45, but no. All right. So some common distractions that might come up during an investigation interview. You want to think about these and have them prepared beforehand for these sort of big ticket capital I investigations. What about the interview demands that the subject demands that the interview be taped? I'm not going to talk to you unless this is recorded. How are you going to respond to that? If you do allow the recording, my personal recommendation is if you allow the recording, you keep your own recording. If you don't consent, you don't consent, you don't do the recording, you don't have the interview, but if you do, you want to have your own recording, because especially as people get more technologically savvier than me anyway, recordings can be doctored. The interview subject demands that a parent or a friend or a coworker or an attorney be present during the interview. In the ordinary course of business, an employee doesn't have the right to have an attorney present when they're talking to their boss about an HR matter. Typically, we say no to those. Sometimes I say yes. Kind of depends on what the district wants to do in that case. Changes the dynamic a little bit. I've had people wanting their spouse to be there, their pastor to be there, their neighbor to be there. For data privacy reasons, in cases involving minors, I say no to all of those things, but usually I allow a space outside. Hey, you want to talk to your pastor or your spouse afterward? That's great. They can't be here for data privacy reasons, but there's a waiting room or an office across the hall, and you can go and get all the emotional support you need. And if you want to take a break and go get emotional support, that's fine. I'm a more flies with honey approach to my investigation interviews kind of thing. Okay, but what if the subject refuses to answer questions? How are you going to respond to that? Are you going to move on? Are you going to try to ask a different question? What if I mentioned this one, the advisor, whoever tries to answer questions for the person? Again, my approach is to remind them gently that I'm here to get that person's firsthand information, and what they're telling me is not the firsthand information. And then maybe you just discount at the end, or maybe you say that's enough, we're going to go on without you. It kind of depends on the situation and what you're looking at. What if they ask who you've interviewed or who you plan to interview? I always tell them I can't answer that question personally. I don't want to answer that question. You can guess who I'm going to interview based on the people that I've mentioned, but in Minnesota, it's a specific data praxis thing. I can't. It's a FERPA thing, and for everywhere if you're talking about students. But it's data on the student or educational record. The fact that I interviewed them, it may be inextricably intertwined with other data or other educational records, but I can't tell you what Susie said in her sworn report, or what Mary said in her not sworn. Sorry, got ahead of myself. What Mary said in her statement. I can't tell you. That's data on her. What if the employee asks right out of the gate, or the student asks right out of the gate, oh my God, am I going to get suspended? Are you going to fire me for this after they find out what it is? No answer right away. No decision has been made. We're just here asking what happened. Unless you're admitting something, then we can move on, right? But no decision has been made. I get this one now and again. I don't want to participate in an interview, but I will answer written questions if you send them to me. I used to say I always say no. There was one time I said yes, and it was every bit as valuable as you think that list of written questions that was filtered through. It was written questions to a disabled student who said that her disability prevented her from participating in a live interview, and the IEP team said, yeah, she probably wouldn't do a good job interviewing. The questions were filtered through the parent and the parent's lawyer. And even with all of that, the student admitted that she lied to me. So actually it had a little bit of value at the end of the day. So that was one of those safety investigations. I was in an IEP meeting, and the student said, I can't go back to Mr. Smith's classroom. He touches my boobs. Now that'll bring your IEP meeting to a screeching halt. Just immediate, me and the other lawyer, out in the other room. Okay, let's go. We're going in a different direction. She's not going back to that classroom. Well, rather she is, but Mr. Smith or Mr. Johnson or whatever I said isn't going to be there. And then we're going to have to talk to her. So that was one of those immediate investigation kind of things. But in any event, that's the only time that I've ever done written questions because the student could not participate because of disability. Lawyers love to get written questions because we like to write the answer in the most, lawyerly way possible. A, we get to charge the client, but B, we also get to control the narrative. And parents want to control the narrative too. No, I'm not giving you written questions. You can participate or not. What about data practices? What about data privacy considerations, rather? FERPA, I mentioned earlier. Just a quick, if anyone wants to jump in, have you ever heard of or used a Garrity warning? So Garrity is somebody unmuted. Beth?
Yeah, well, I've used the Tennyson. Is that similar to Garrity?
Tennyson is similar to Garrity. Tennyson explains what happens with the data that you are going to collect, who's going to use it. Garrity warning, it's named after a U.S. Supreme Court case called Garrity, of course. And that is, it contains the elements of Tennyson warning, but it also directs an employee. This is only usable for employees to answer under penalty of insubordination. You must answer this question. You must answer the question truthfully. The U.S. Supreme Court has said that a public employer cannot direct an employee to self-incriminate, basically, under pain of being fired. Unless you give them this warning, which says anything you tell me after I direct you will not be used against you in a criminal proceeding. So that's what a Garrity warning is. And do you need to issue one? Maybe, maybe not. Just something to keep in mind down the road if it's if it's something that is of interest to you. Interesting point. You can't use a Garrity warning in Title IX proceeding because Title IX says that all participation must be voluntary in interviews. Even if you really wanted to, let's assume the case against Mr. Johnson becomes a Title IX investigation. He says he doesn't want to answer, hypothetically. You can't compel him to answer because Title IX regs say so. All right. I'm going to stop talking about Mr. Johnson and Mary and Jane for a minute. I got another hypothetical. John Smith, who is not related to Jane Smith, by the way, is a staff member in the school, and part of his job is to collect ticket and concession money after or during school events, dances, football games, whatever it may be. Mr. Smith is supposed to lock up the money in a desk drawer after the event and give it to the principal, who doesn't go to the events because the principal's got other stuff to do, right? Mr. Smith's supposed to give it in the next day. The day after a particularly good chess club match, good ticket sales, great chess concessions, Mr. Smith comes in and says, look, I counted all the money last night. I locked it in the desk drawer. And when I went to give it to the principal this morning, it was 25 bucks shy. Oopsies. I clicked too far. I thought I had a second slide for you. This one's a little more simple. So sort of sticking with the stuff we've talked about so far, the foundation, what's the scope of the investigation? Is this something you might use an external investigator for? And how are you going to proceed with the investigation? How about, this is a shorter one, and it will take us, I said I'll give you a break at 5 o'clock. How about we come back at 4:58, Russ, we can give him 5 minutes, and then we'll answer these questions, and we'll take a quick break. We got John Smith, Mr. Smith. He locked this money up, the chess club concessions, after a particularly, riveting chess club match, a lot of popcorn sold, and 25 bucks was missing out of the till the next day. With what we've talked about, sort of that foundation and that scope, what is this investigation? What are you thinking? What's your strategy going into it, based on what we've talked about? Anyone?
Well, our group talked about asking some more questions, like how does he know? Did he miscount? Is there any sort of deposit slip that would record? Is there how many 20s, 10s, etc.?
Sure.
Do they require 2 signatures, or is it just his word?
Sure.
Is there any video to that room or going in and out? Who has access or keys to that room?
Is this one you think that you would do an internal investigation on, or you do an external investigation?
Start with us.
I would say internal to start with.
Makes sense to me. Yeah, unless we find out that Mr. Smith is the superintendent or something. Absolutely, this is an internal investigation. Looking at it, ramifications are you're out $25. And whoever took it may have committed a crime, but it's not, going to have district-wide repercussions. You mentioned some things you'd be looking at: strategy, who else saw it, who else signed for it, all of those things. Absolutely. One person that wasn't mentioned, but is a potential suspect, if you will, is who is the night custodian there, who had access to that room or that drawer. And I'm sorry, I was going to let you talk. If somebody else has some other things that they thought about, please.
No, you said it. Start checking cameras, start checking access. Double count the money again. Maybe there was simply a mistake in counting the money. People do that.
Sure. All right, absolutely. So I'm going to say it's 5 o'clock. You're all school folks, so you're used to taking a 10-minute lunch break, right? At least that's what my kids tell me they get for lunch. So I don't think that's true. I've looked at the calendar, but it's not much more. Automatically ripped my headset off, which actually was accidental. I apologize. I had my leg crossed and hooked myself. I guess that's time to get a wireless one, assuming this one didn't become wireless just now. But in any event, why don't is 10 minutes enough, everyone? I'll sort of go by your gauge. When we come back at this point, 5:11, and we will continue through.
Thanks, Christian.
Thank you. We are back at 5:11. If everybody's ready to continue, I minimized my chat and I can't figure out how to get it back. So that's an interesting technological foible on my part. So don't count on me.
Keep an eye on it for you, Christian.
Thank you. Don't count on me seeing it anymore, since I somehow can't get it back without possibly changing my screen settings or something. Oh, wait. Haha, okay. It's back. I told you earlier I'm not a tech guy and all technical things are my fault, but I want to move into the detective part. We've talked about laying the groundwork and procedure and why we're doing this. That's not what you guys wanted to hear about. I know that. You wanted to hear about asking questions, and also my love of TV detectives. So there are going to be a number of them, and if you don't know who they are, I will probably point them out. But this is Monk. If you watched Monk on USA or whatever it's streaming now, it's a fun show. I don't get any kickbacks from any networks that I'm aware of, but if anyone's watching this, I would appreciate some. But no, I grew up watching a lot of TV detectives, and my wife loves Monk, so here we are. Interview basics. I start with opening remarks. I said earlier, I'm a more flies with honey kind of person. This is not even that. This is just opening remarks. Explain what you're doing there. And what's the purpose of this interview? What are you looking into? Especially if you're going to have multiple investigations going, like our earlier hypo about Jane and Mary and Mr. Johnson and all that. What is the purpose of this particular interview? And explaining the process. And your role as an investigator. I'm here as part of an investigation. Okay, great. What's that mean? Well, I'm looking into allegations of misconduct by another employee or by another student or by you, depending on who we're talking to. But what is the purpose? What is your role? You wear a lot of hats in the school. If you're the Title IX investigator, I'm not here as the administrator. I'm here as the neutral fact finder. Otherwise, you're the guy who always disciplines me or the lady who always disciplines me. I'm not here in that role. I am here as a fact finder. Whatever your role may be, you want to be clear about it. At the same time, you don't want to minimize the complaint. This is for whoever you're talking to. We received another complaint about you being a jerk to kids. I know it's not true, but we got to go through with this. Okay, great. What is that? What are you really telling that person? Or, okay, Mary, let's get this over with. Why did you say that Mr. Johnson's hooking up with Jane? Okay, let's get this over with. You're minimizing the complaint. You're not here to take sides. Whatever role you have otherwise in the building, whatever it may be, you're not here to take sides. You're here to be as impartial during this interview as possible. You want to explain, like I said, the process. You want to say you'll follow up. The district will follow up on the information that it receives. And you want to talk about retaliation, especially depending on how sensitive the situation is. Again, this is for capital I investigations, not just, hey, Billy, did you kick Susie down the slide earlier? This is, you want to talk about retaliation. You prohibit retaliation. Whether you have a policy on it, I know you prohibit retaliation. The process doesn't work if you don't prohibit retaliation, so I know you prohibit retaliation. So you want to tell people that. report any conduct by the alleged wrongdoer. Hey, if Mr. Johnson tries to get a hold of you, I want to know, physically or literally, I guess, depending on who you're talking to. I want to know, did Mr. Johnson reach out to you and tell you to stop talking about him? I want to know what retaliation might look like. Did Mary follow up and say, how dare you narc on me, you little, you know what? I want to know about it so we can get back to it and respond to it immediately. You don't want to promise confidentiality. This is another one of those things that the school I mentioned that got in hot water with OCR the dean didn't do right. The dean said, this ends with me. I will provide, sort of these supportive services. I will try to, make the other person understand why they can't grab you, things like this. This doesn't need to go anywhere. And I get a lot of pushback on this one from deans and social workers and counselors that I give investigation training to. You're trying to build rapport with the students. You want them to know you're a safe adult. I get that 100%, but it cannot die on your desk, or you are the reason that the school is aware of harassment, for example, and is deliberately indifferent to it because you let it die on your desk. Not a good look, not a good look for the school, not a good look for the employee. Also, they're subject to data practices laws. FERPA, if a student writes down in their, if you write down in an interview with the student that they are being abused or that they are, in a relationship with somebody or whatever it is, and that goes in your notes as a counselor or a social worker or a dean or an investigator, it's subject to FERPA. It's subject to other data practices laws. So if Billy writes Susie writes that Billy pushed her down the slide, or Billy writes in a more serious example, if the counselor writes down that Billy reported to me that Susie sexually assaulted him in the bathroom or in the hallway, you can't just leave it there for liability reasons and for legal reasons. It goes to the people that FERPA says it goes to. I get a lot of pushback on this too from, like I said, from counselors, not just because they're trying to build rapport, but also, well, what about HIPAA? This is HIPAA data. I'm a school psychologist and this is covered by HIPAA. No, it isn't. It's covered by FERPA. There's a whole joint guidance from the Department of Justice and Department of Education explaining how that's not HIPAA related data. It's FERPA related data, which means that people in the school have a right to see it, get to see it. So, side note, nothing to do with investigations. I had an IEP, an idea due process hearing rather, where I found out during the resolution session a couple of days before the hearing that the nurse had a huge file of relevant medical information that the nurse had never provided to the special ed team because it was covered by HIPAA. It was not covered by HIPAA. Even after I gave her the joint guidance, she wouldn't give it to the people who needed to have it. A, we settled the due process hearing because we had a loser of an argument after finding that out, and B, that nurse didn't work there anymore. So long story short, you cannot promise confidentiality. Don't do it before an interview, an intake. Hey, I got a problem with a student, another student. I really just want to tell you about it. I don't want to go anywhere, but Billy grabs me in the hallway. Thank you for telling me. I can't tell you that this is gonna, not go anywhere. That's a serious thing and we have to report it. Specifically sexual harassment, other forms of harassment too. If I just have a problem with Billy, I think he's a jerk, I think he's cheating off my test, fine. That doesn't have to go through the whole rigmarole, right? But, certain things have to get reported. But B, it also is part of covered by FERPA and other statutes that govern data and access to it. Okay, so that's what you don't say, and that's how you set it up. What about the questions? What are the right questions? In this case, you want to ask the journalism questions. Who, what, when, where, why, and how. You want to be as detailed as possible. You don't want to allow an interview subject to make generalizations or offer conclusions as opposed to facts. And I'll throw one conclusion out there. I was assaulted. Billy assaulted me. Assault is a conclusion. Assault is what you're looking to prove. What did Billy do? He assaulted me. Okay, how? How did he assault you? Well, he assaulted me. What exactly? What part of him touched you? And where did it touch? When did this take place? Who was there? Or if they didn't say it was Billy, who assaulted you? I was assaulted. Who assaulted you? Billy. When? In the between third and fourth hour. Where? In the hallway. How? How did Billy assault you? He punched me, he pushed me, he kicked me, whatever. Why? Why is a good question to know. It might go to something. It might make it harassment, not harassment. You want to dig into it. And those conclusions. And this this leads into the next thing I want to comment is to make sure you ask the tough questions. Some of these will be uncomfortable questions. If we're talking about sexual harassment, sexual assault, harassment based on perceived gender identity, things like that, these are tough questions that you're going to need to dig in. I did an investigation one time into an allegation about how a school responded to finding out that a student had been sexually assaulted by another student. And I had to ask the tough questions, not because I wanted to ask these questions, but how did you know, you say that you were sexually assaulted or your child was sexually assaulted. How, what happened? Well, this boy, pulled down the other person's pants and, and then get those details. I didn't want to hear the details. Details are heartbreaking. But can't leave it at a conclusion. My child was sexually assaulted. How? Sorry, I'm not asking this because I'm, going to get any pleasure in asking this. I need to know how, so that I can ask the other person what happened and, be able to, get their definition, and just so I can figure out what happened. So those tough questions, and it might might be non-sexual and still be uncomfortable. I think you're selling drugs. Well, I need the money to pay for, my mom's operation, whatever it might be, or I just don't want to tell you because I want to get in trouble. You have long-standing rapport with some of these children. You see them every day, certainly. You have long-standing rapport with your coworkers and your subordinates. You see them at work all the time. These are going to be tough questions, and you need to ask the tough questions, or otherwise you get a result that just is full of generalities and conclusions, and you can't make head or tails of it. Assault is a conclusion. Harassed is a conclusion. Stole is a conclusion. Billy stole my coat. Stole is a conclusion. That implies intent. What did Billy do? Billy took my coat and didn't give it back. That's the how. So you want to ask those tough questions. You want to ask about documents, and I say documents, but tangible evidence, things that support it, make it more likely or not. I said earlier, for you, districts, you need to write this down as evidence. What evidence does the complainant or the respondent or the witness have? My hypothetical earlier mentions Bill has some pictures. Great, let's, do you have the pictures? No, Bill only showed them to me. When you get to Jane, hey, I heard Bill has pictures, or I heard there are pictures out there. Do you have any pictures? Whatever the answer may be. That's a tough question. You want to make sure you get those tangible records. Hey, and you may have control over them as the district. It may be surveillance footage. It might be the footage on the bus, whatever. What do we have? I've had a lot of cases where students not only fight but have somebody record it for them, and great. Can I have that recording? I mean, it's not great that you did that. You probably shouldn't have recorded it, but can I get that recording that's out there? You want to ask the interview subjects, whether it's the complainant, the respondent, or other witnesses, another who question. Who else might have seen this? Who do you think would be a good witness? Not just to character or, Billy's a great kid or, Susie's a liar, whatever it may be, but who do you think saw this, heard this, would understand, would be able to provide me information? You can't guarantee results. Just like I said earlier, you don't want to tip your hand and minimize something. Don't worry about it. Mrs. Smith, we are going to make sure that Mary is expelled and never comes near your daughter again. And we're going to, kick Mr. Johnson out. You just invalidated the whole investigation in that first comment. You've reached a foregone conclusion. Same thing. Don't worry about it, Mr. Johnson. These crazies happen all the time. We know you. You've been a teacher here for 20 years. We know you wouldn't, touch a kid. How's that going to look, if that comes out? You can't do that. Okay. A few more tips. Another great TV detective, maybe going back a little bit, but we're going to talk about Just the Facts, Ma'am. Just the Facts from Dragnet, of course. Sergeant Friday there. Some tips for interviewing the complainant and fact witnesses. I don't know where that one's streaming. I can't give a shout out. But you want to start with short, open-ended questions. And again, the journalism questions, like I mentioned earlier, the who, what, when, where, why, and how. Short, open-ended questions. I love leading questions as a lawyer. I love cross-examination. It's fun. This is not the time to do it. So Billy pushed you down the slide, didn't he? How's the kid going to answer that? Agree. Yes. You asked me a question in a way that makes me feel like I have to answer yes. This is not the time for it. You want to get the witness to talk. The witness should do more talking than the investigator. This is not the time for cross-examination. I don't care how many of these TV detectives you've watched or courtroom dramas. I always say Jack McCoy has better writers than me. I'm my own writer. But you don't want to do the cross-examination. A little bit of leading question might be okay. Hey, you were in school on Wednesday, weren't you? Okay, for a foundation thing, if the thing happened on Wednesday that you're investigating, sure. But going from there, it kind of it gets to be a little bit of a habit. Okay, you were in school on Wednesday, weren't you? You went to math class, didn't you? You saw Mr. Johnson in math class, didn't you? And you stayed after, right? I think I saw that on camera, right? Now, is it your idea or is it the kid's idea? Especially with kids, I don't like leading questions. I mentioned the journalism question, and you're talking about personal knowledge. Follow each line of questioning to its logical conclusion. You don't want to have any inferences or any gaps. If there's an alleged assault that happened in math class on Wednesday, were you in math? Did you go to school on Wednesday? Yes. Were you in math class on Wednesday? Yes. You have math third hour, right? Yes. There's one leading question. It's the only one I'll ask in this. Is Johnny in math class with you? Yes. Was Johnny in math class on Wednesday? I don't know. I don't remember. Okay. If Johnny says he was in math class on Wednesday, would you have any reason to disagree with that? Whatever. Do you remember seeing anything in math class on Wednesday that stood out? No. Do you remember hearing about anything? No. Were you looking at the front of the room the whole time? Yes. Or looking at your book the whole time? Yes. Okay. We're getting to, did this witness see the big fracas that happened behind him or her? So it's much, much longer than just asking, hey, did you see the fight in math class on Wednesday? That's a great question to ask eventually, but if you start with that, the answer is no, and this witness doesn't have any more useful information, especially if we're talking about a complainant, or the subject. We want to make sure we get that person in the room, in the area, around the same time before we give them a chance to say no, but I didn't do anything. So anyway, you want to assume that you have to defend the interview questions in court or to an administrative agency. So again, in addition to not guaranteeing anything, watch out for your bias. Make sure the language you're using is professional. Of course you will. I know that, but you got to say it. I've got to say it. You want to make sure that it's just your views don't come through. Again, like promising results. Don't worry, we're going to get rid of this. Okay, did you tell the subject you were just going to get rid of this? Yeah, I did. Sorry about that. So how can you say that you didn't have a bias there? You want to observe witness demeanor and see how they're responding. Are they making eye contact and looking down? Are they staring at you? Are they turning red? Things like that. And I'll explain why in a little bit. You want to ask follow-up questions. Again, no gaps here. I don't know, or I don't recall. Okay, let's break it down. You don't remember if you were in math class on Wednesday. Do you remember if you came to school on Wednesday? Well, it depends. Was it last Wednesday or Wednesday in 2014, right? But okay, let's say it was yesterday. Do you remember coming to school yesterday? Hey, do you remember when I saw you in the hallway yesterday? I remember you were wearing red shoes, if that's something that you can say, whatever it may be. Or if they say, I don't understand the question. What part of the question, how do I make this easier for you to answer my question? If you think a witness is being evasive, you can circle back and come back to it through another line of questioning at other points in the interview. If the witness doesn't want to say that they saw Susie, get them talking about math class, get them talking about what happened. Do you remember yesterday's lesson? Did you do your homework for math class? Can I see your homework for math class? Okay, you remember we were talking about long division or whatever you're doing in math class. All right, hey, who do you sit by in math class? You sit by Billy and Johnny. Okay, great. That faces the front. Yeah. Does Susie sit in front of you? Yeah, Susie sits in front of me. Okay. You remembering that you might have seen Susie in math class yesterday, things like that. And it's fine to express sort of incredulity if somebody says, I don't know. You don't remember if you were in school yesterday? Really? It was only yesterday. You sure? That's fine. And especially with, older children and adults, certainly I wouldn't say something like that to a kindergartner probably, but, I've been accused of being mean-spirited before, so I might, but I know you wouldn't. But in any event, especially if it's something surprising. If you ask them, what did you have for lunch 3 weeks ago? Okay, nobody remembers that. But were you in school yesterday? I don't know. Really? You don't know if you were in school yesterday? Sometimes a visual representation might help. It just might, I guess I jumped slides too soon, sorry, but in any event, visual representation might help. Drawing a picture of the alleged incident or the scene where the alleged incident took place might be helpful to walk to the site of the alleged incident so that the witness can point out what happened there. And another investigation from when I was a very new attorney, I had 7 staff members say that they saw another staff member who was wildly unpopular with the other staff, by the way, do something inappropriate during a hold, a special ed restraint. They said that the kid spit on this teacher and the teacher wiped the spit on the kid. 7 staff members. They were all lying, and they proved to me that they were all lying through a visual representation. I asked the first staff member to draw a picture for me of the hallway where this took place, and staff member did a fine drawing, drew the pillars and the doors and the doorways, all that. And I asked each of them to, on a copy of this drawing, show me where the other 6 people were standing. And each of them pointed out that the other 6 couldn't see anything. I was the only one with a clear line of sight. So unless this, teacher and this kid were just spinning in circles with her constantly wiping spit on him, they were all lying to me about what they saw. They'd gotten their stories straight together. I'm not saying that happens every time. Most of the time, the visual representation is just me doodling in a margin, and it adds very little to the investigation, but it helps me get my head clear around it. What are we talking about? What hallway, what room are we talking about? If I'm coming into a school, especially for the first time, or I haven't been there in a while, I want to see the classroom. I want to go out to the field where it happened, whatever it may be, just to see that extra level of, is it possible? If somebody is saying they were attacked in a bathroom, let's go look at the bathroom. Is it a single stall bathroom? Is it, was it 20 people there in a locker room? What is it? During this investigation process, I guess I should be on this slide. Oops. You do want to be as disclosing as little as possible. You don't necessarily want to just jump out and say, okay, this is everything that happened. What's your opinion on it? You want to start slow and work your way in. You can use your discretion how much to tell any witness about the complaint. You want to ask a complainant if the extent of the complaint's been covered. Hey, did I go over everything you wanted to tell me about? You want to make sure that way the complainant doesn't come up with something later. If the complainant says, yeah, I wanted to tell you about, math class, but also I got attacked in art class, they had a chance to tell you, right? And you ask them, hey, is there anything else you want me to know about your fight with Johnny? Did anything else happen that you want to know about? Which then reduces the risk of somebody saying you didn't respond appropriately, because you can only respond appropriately to things you know about. And if something happened in art class and you didn't hear about it, you only heard about math class or gym or whatever, subject it may be, you want to make sure that you've asked the complainant about everything. You want to ask witnesses not to talk about what they talked about with you to other people. And I try to make that one as light as possible. I say, look, I'm going to ask you not to talk to other people about what you talked about with me today. And I'm doing that for 2 reasons. First of all, it makes my job harder. And, as the investigator, you know how people are when they talk. The more people talk, the more people sound alike. Whether it's intentional, whether it's subconscious, I don't know. I don't really care. I just know I get a better story or a better, more honest picture of things when people aren't talking about what they talk to me about. And the other thing is, look, you got enough going on, whether it's an employee and I say you got a hard enough job as it is, you don't need this kind of drama. Or if I say it to a child, look, it's hard enough being a 6th grader, 8th grader, 9th grader, whatever, without people talking about this, right? You don't need this kind of stuff in your life. It's just better for everybody if nobody talks about what we're talking about with me. Sometimes, depending on the age of the child, I say I like to consider my investigation like I'm a ninja or a spy, that I'm in and out, nobody knowing. So whatever way to make it sort of palatable, but ask them, don't talk about what you're talking to me about with somebody else. But you do want to ask the complainant about the impact. How did it make you feel? What impact did it have? This is especially true if we're looking at harassment and we have to find out the impact, whether it deprived that student of an educational opportunity or deprived an employee of the benefits of a program. You want to know, yeah, I was afraid to come to school, or yeah, it didn't really have any impact. I mean, I thought they were joking, or or anything in between the two there. It was okay the first time, but after that, it got weird. I just completed a sexual harassment investigation where it was, the first time that this kid touched me, it was okay. I didn't know how I felt about them, and it was okay. But the third time, we were done. I was creeped out, and I told him to stop. And it's after that third time that she or he started to bother me. So that, get an honest answer on that impact. and why it matters. And then also, by the way, it sort of pins them down because they say it didn't bother me, but later they come back and say, this is the worst thing that ever happened. I can't go to school and I'm suing you for a violation of some law because it's a hostile educational environment. Say, well, I asked you and you said it wasn't really bothering you. Now, will that hold up? Not necessarily, but it's a good fact to have. You want to understand the complainant's concerns. The complainant might be embarrassed. You know, things that are personal are embarrassing. Being a victim can be embarrassing, even an alleged victim. The complainant might fear retaliation. You want to be compassionate, again, without guaranteeing results. You want to ask, I often ask what the complainant would like to see happen. Not always with students in particular, because, you know, students want a pony and, you know, a castle and things like that. But with staff members, what do you think? Where do you think this is going? What do you want to see happen? I don't promise that it's going to happen. In fact, I say I can't guarantee that will happen. I'm just curious, you know, because that's another way of asking the impact. You know, if it's something that, it's not really a big deal, but I want to see him fired and kicked out and shot in the street. Like, well, hold on now. It's not a big deal, but you're asking for a lot there versus this is the worst thing ever. And I just want him to get a warning. You know, what is, or heard a warning? What does that mean? So it's just another question there. Again, you want to take any appropriate action. Like if the complainant says, I don't want you to go anywhere, I want this to be over. You can't say that. You know, we have to follow our policy. We have to follow the law. We have to look into this for your safety, whatever it may be. Again, you don't want to make promises about who will be interviewed or when the investigation will be completed. I get that all the time. When are you going to be done with this? I don't know. When it's done. I sometimes give a ballpark figure of like 2 weeks from the date of my last interview, but that's a ballpark and it's usually slower than that, sometimes faster, whatever it may be. You know, I don't disclose the identity of witnesses. Who are you going to interview? I don't know yet. Well, see who are the witnesses. And again, mentioning retaliation, prohibiting retaliation. Please bring retaliation to my attention, to complainants, to witnesses. All right. Talking about interviewing the alleged wrongdoer. First of all, you're going to watch out for your biases there too. Are you going to go in and say, like I said, downplay it as this is just another, you know, stupid comment by a kid who doesn't get the new math or whatever it is? Or are you going to go in there fire and brimstone and say, this is the worst thing you could have done. You have betrayed the trust of the school and I'm going to run you out of here on a, you know, rail tie. Like, well, no, hold on. You're not going to do any of those things. You're going to watch out for your bias. You're going to be professional. I know you are, but some of these things can get a little heated and you want to keep that in mind. You're there to be a fact finder, not, you know, the voice of doom and ruin there, or, you know, putting it under the rug. Yeah, again, we want to talk about representation. Do they have a right to a representative under Title IX, for example? We're going to do all the required notices, and I'll talk more about Title IX in a little bit, all that. But we want to start again with the opening remarks, the role of the investigator, ground rules. If this is being recorded or virtual, we're not going to talk over each other, things like that. Ground rules regarding whether the advisor is going to be able to talk or that we'll deal with them later. Similar statements that were provided to the complainant. And I like setting the tone as an example. That's not something to say, but just you're going to set the tone, sort of a measured voice, you know, okay, thanks for coming in. Appreciate you coming in, taking the time, even if you didn't have a choice, you know, things like that. You want to just set the tone for what's going on, because that will set the tone of how the subject responds to you. All right. Another famous TV detective, Hercule Poirot. I guess he was a book detective first, but, you know, I've seen him on TV more than the books I've read. So some specific strategies. You want to, like I said, ground rules. We want to talk about refusals to answer. How are you going to respond? Okay, you don't have to tell me. That's fine. But if you don't tell me, I don't have the information you could have provided me, or, you know, coming back to it, asking a different way. You know, really, this might be your only opportunity to tell me your version of things before we make a decision. A lot of times that's all it takes. Well, okay, gosh, if this is my only chance to tell you something. Now, of course, in Title IX investigations, it's different because there's the written complaint responses and everything. I'll go into that again in a little greater detail. But, you know, for now, just saying this is the only, maybe the only chance you have in most kinds of things. Hey, heard you called Billy a racial slur. I don't want to tell you anything. I don't have to tell you anything. Okay, that's fine. I'm just going to go along without what you could have told me. You sure you don't want to tell me anything? That's usually enough. Follow-up questions, asking the good follow-up questions. You know, just one more thing. That's Columbo, not Poirot, but it's one of my favorite questions. Just one more thing. I'm coming back to it. what is the, the follow-up question? Were you in math class? Sure. Did you have your homework out? Yeah. Okay. Did anything happen while you had homework out? Asking those questions, get the full response, not letting the person clam up after an I don't know or a no. Okay. You want to be blunt. Don't dance around delicate topics. Ask the question directly. And that is to say, not to use euphemisms unless you're talking about a racial slur and you don't use that slur. But if you're asking Billy, did you sexually assault Susie? No, you just ask conclusion. You want to ask, okay, Billy, I heard you put your left hand on Susie's right thigh, or whatever it may be. You want to ask those blunt questions. Did any part of you touch Susie? What part of you touched Susie? What part of Susie's did that part touch? Whatever it is. Don't dance around the delicate questions. You can certainly turn red and be embarrassed in the privacy of your own office, but right now you have to ask these questions. You want to ask why. Wrongdoer says, yeah, I punched Billy. Why? Why did you punch Billy? It's Tuesday. I punched Billy on Tuesdays. Or, Billy stole my money. Or, Billy's dad said he, was going to kill me or whatever. We're going to talk about credibility a little bit, but in the next little chunk, but you want to ask those questions about the other person's credibility. If the alleged wrongdoer denies the allegations, I love the question, well, why would the other person lie to me? Why would Susie lie to me? And it's not just the complainant, it's the other witnesses. And sometimes I say, does any reason anyone would lie to you? I just completed an investigation where the employee resigned in the middle of the investigation because the employee was adamant that the complainant was lying about them. But then I asked about some of the other witnesses who this employee thought they were on very good terms with. And when the employee realized that they weren't on such good terms, the employee, sort of had a change of heart and didn't want to go forward with it anymore because, okay, there's no reason why, A, B, and C would lie about me. Okay, well, if I told you that A, B, and C said that you did whatever, oh, okay, if they're saying that, because they don't have a reason to lie about me. So, and it's good when you're balancing credibility later. Closing remarks for the complainant. Hey, one more thing. Is there anything else you want to tell me? Anything other information? Explain retaliation. We don't allow retaliation here. You heard me mention a lot of names during this interview. The school prohibits retaliation. Here's how we define retaliation as broadly as possible is how we define it. Don't take any action that could be have the appearance of attempting to influence this. And if it's an employee, tell them not to talk about it with anybody again. Student, you ask. Employees, you're a little more blunt with. You want to be prepared for anger and defensiveness. Oh my God, you're coming to me with this. This is just garbage. How can you? You want to insist on those details of their version of the facts, not just a general denial. I don't like to just state the complainant's allegation and ask the alleged bad actor to simply verify or deny. That's a short investigation, not a lot of nuance. Did you push Billy down the slide? No. Okay. Now we're stuck in a corner. But again, I mentioned earlier, hey, did you go to recess on Thursday? Yeah, who do you play with on recess? Were you playing on the slides? Hey, you haven't seen Billy on Thursday? Okay, was Billy on the slide? Did anyone push Billy down the slide? I heard you push Billy down the slide. You push Billy down the slide? Okay, well, Susie told me you pushed Billy down the slide. Is that, why would Susie lie to me? Well, Susie, was jealous of my cat, whatever. But going through, instead of just starting with that one question and moving on and saying it's he said, she said, because you want to balance credibility. Don't make any threats. I'm pretty sure that should be obvious, but hey, we're going to run you out of here, you scumbag. We know what you did. You're going to be expelled. You're going to be fired. Okay, you've made a threat during this fact-finding interview. Don't describe any disciplinary action, even if they ask. I don't know. Anything's on the table. Disciplinary decisions will be made later after the end of the investigation. Right now, this is where we are right now. Now, again, if the student's already been suspended pending the investigation, that suspension stays in place, but the final outcome, you don't know yet. Again, don't reveal the names of witnesses if you can avoid it. Now, I usually like to say things like, I've heard that you did X, but sometimes it's unavoidable. I mean, if there's only two people to a conversation, did you ask Susie to send you a naked picture, whatever it may be? There's only two people there and, well, gosh, somebody must have told you and it must have been the other person, but I don't come out and say who it is. And then emphasizing that retaliation is prohibited. One other after we're doing these interviews, we need to measure credibility. And the questions, as an investigator, the questions that I've mentioned earlier and insisting on those specifics and circling back, those are all credibility things, and that goes to internal inconsistency. If I ask you if you were in math class and you say yes, but then 10 minutes later you say, no, actually I skipped math class. Now you're lying to me one way or another about being in math class. And I can verify it. I can check the surveillance camera in the hallway, right? So we can find out about that. But there are all kinds of credibility clues: eye contact, unnatural or inconsistent hesitation, blushing or turning white, things like that, change in a pitch or voice, change in just an affect over the course of the investigation. I'm answering every question like this, and then when you ask me the one question, I break down crying. Now, it doesn't mean that I am guilty or anything. It just means that something changed it. And what could that thing be? Maybe because I'm lying, or maybe because I've been, badgered into this, whatever. So another reason why I try to keep a level pace and I don't talk too fast, unlike what I'm doing now. Change in sort of the person's attempt to direct the outcome of this, sort of, making a threat or just trying to lead the conversation away from something. That's credibility. I don't want to talk about math class. Oh, I had Jell-O for lunch. That's great. I'm here to talk about math class. I played the tuba in band. Great. What happened in math class? Oh, I played on the swing set with Susie, whatever. And then, of course, an obvious one: statements reflecting a skewed version of reality, whether it's I get to do that because I'm a boy, or, my dog told me to murder somebody. That's not a Sam, hopefully not a thing that you end up with in school, but, whatever is the skewed version of reality. It's okay for me to do that because of X, the antenna that are in my teeth, whatever. And it doesn't have to be that skewed, but just, it's okay for me to do this because of X, or, I couldn't have been in math class because, Wednesday is the day that I visit my grandma in the nursing home, and the mom is saying that you never visited your grandma in a nursing home. That's probably a lie then. You want to look at that. Another thing is consistency. I mentioned earlier, there's kind of two kinds of consistency. There's internal consistency, which is to say, was the witness consistent in their story throughout? It is a well-known dirty lawyer trick to ask the same question 3 or 4 different ways. I pretty much admit to it. I say, look, this is a dirty lawyer trick. I've probably asked you before, but I can't remember. That part's usually not true. Were you here on Tuesday? It's not in my notes. I'm telling you up front what I'm doing, but I'm doing it anyway. Not everybody does that. That's my approach. But you're asking 2 or 3 different things. And even if you don't use any dirty lawyer tricks, or police do it too, of course, but asking, so do psychologists, by the way, but that's neither here nor there. Even if you're not doing anything like that, and you want to get to just the end of it, and you want to look at your notes and you want to think, okay, well, first he said he wasn't here on Wednesday at all because he was visiting his mom in the nursing home. Then he said he was here, but he skipped out of math. Then he said he was doing his homework in math class because he remembers Mr. Johnson, looking at his math homework over his shoulder. Okay, which is it? What version of this is true? That's an internally inconsistent statements, and that has merit or has bearing on credibility. There's also external credibility. Is this consistent with other evidence that other witnesses have said, with surveillance footage, or is it just consistent with good old common sense? Now, I don't use that one too often, but I have one example. It was a Title IX investigation I did some years ago. A student alleged that she had been assaulted, raped specifically, in a bathroom by another student. And these are the facts that came out. The student said that she was lured to the bathroom twice, 2 days in a row, by this other student. The other witnesses said, well, they were texting, and in fact, she told me that she's the one who invited him. Okay, the first day anyway. Then the student says they had sex or they engaged in sexual conduct, but she also says she blacked out and was forced at one point. No bruises. Okay, no bruises. Maybe, didn't hit the floor that hard. The video, there's no surveillance in the bathroom, of course, for all kinds of obvious reasons. The video outside of the bathroom, though, shows the student, A, getting there first, B, letting the male student in, C, leaving first after 10 or 15 minutes, and sort of skipping down the hall and stopping to get a snack out of a vending machine. Does not look like somebody who was beaten to the point of unconsciousness or had engaged in anything that she didn't want to engage in. That also showed a similar pattern the next day or the next occurrence. And the question was asked, well, why'd you go back? And if this boy assaulted you the first day, why'd you go back? And she didn't have an answer for it, really. Somebody else said she might have been threatened, but threatened in the here and now versus and they weren't in the same class. They arranged at the same time to ask for a hall pass to get out to go to the bathroom at the same time. This was orchestrated over text messages, which became apparent, and several witnesses. But external credibility or external consistency, everything the student said was not reflected by other evidence, other student statements, her behavior before and after the incident, the video evidence, things like that. So if somebody says that they got the snot beat out of them on the football field, but then they go back to the game the next day, the same thing, or they come back later and they don't go to the nurse's office, how bad did they get hurt? I mean, it's those kinds of things you can ask. Did you go to the nurse's office? Why not? Well, you said you hurt real bad. You were doubled over. Why didn't you go get help? Okay, you can ask those questions. Okay. I want to go back to Mr. Smith for a minute, the guy who was missing, the staff member who was missing money. I would like to take, let's go 5 minutes again. We'll come back at 5:56. 5 minutes. I want you to come up with some questions for Mr. Smith, and I want you to come up with some questions for Jack Anderson, who is the night custodian who's on duty, and the principal, James Jackson. Those are our characters. Mr. Smith is the complainant for now, it seems like. He's the one that brought this to your attention. And these are witnesses, suspects, I don't know. You tell me. So if you want to, questions for them in 5 minutes, don't have to go all the way through the detailed 20-page outline that I know you'd love to make at 6 o'clock on a Thursday evening, but just some questions and how you might approach them or any concerns you might have with regard to these interviews. So Russ, if we could send everyone away and bring them back now at 5:57 because I can't keep my mouth shut.
Okay, sounds good.
All right, everyone, welcome back. We're heading to almost 6 o'clock. And I just want to, the last ask I had of people going into the breakouts was, what are some questions you might have for Mr. Smith, who is saying that some of the money was taken or is missing anyway, and some of the questions you might have for Jack Anderson, the night custodian, and James Jackson. So what are some questions you might have? Let's start with Mr. Smith.
Well, we thought for Mr. Smith, we would ask, did you count the money at the night? Is it typical that you count the money at night and then again before giving it to the principal?
Okay.
Did you have another person witness counting the money?
Mm-hmm.
And then did you document the bills in any shape or form?
Those are great questions. I think those are three crucial questions to ask Mr. Smith. Did anyone else have any different questions or any other questions they want to add to that? So I have just a couple sort of as a thought. I would ask all those questions certainly, but I like to start broad and work my way in. So I would start with, what's your usual practice? Or is there a policy that you follow? Is there a policy on this you're supposed to do? And then sort of those more detailed questions, the questions you asked are the ultimate questions certainly that definitely need to be asked. Who else not just watched you count the money, but knew you had the money? Who are you working with? Who knows where you keep the money? Who knows where you keep the key? Do you have a key? Do you remember locking up? All of those things sort of go to the questions. And the three you threw out there were just great examples of questions. And I know I only gave you 5 minutes and asked you to come up with questions for three possible witnesses here, but just really just digging in from the beginning, walking through. And and you hit some of the things that I absolutely, who else might be a witness? You asked it beautifully. Who else, knew you were there, or who else counted with you? Did you even count? Where's the documentation? Always asking for that documentation. That's great. How about Mr. Anderson, Jack Anderson, the night custodian?
Okay, well, we came up with asking the custodian if they were in the office at all. If
Sure.
so, and after reviewing video, you may see more too, but what
Absolutely.
time were you in the office if you did? And then also just asking him if he's seen anybody else in the office, if they were in there at the night. Did you see anybody else go into the office?
Sure. Great questions. Anyone else have questions for the night custodian? All right, a few others that might have popped up. Did you lock the room that whatever office this was, if it was an office? Did you notice if the desk drawer was open and was unlocked? Did you see, I think you asked this, but did you see Mr. Anderson there? Or I'm sorry, Mr. Smith there? Who else was there? What's your usual, do you even go in this room at night? What do you do? That kind of thing, just to get at sort of the whole big picture. But those are absolute great questions. And some of these things you might know as as an administrator, as the supervisor, you might have found out from other people. There's no harm in asking, even if you know the answer. In fact, those are the questions that I like the most, the questions I know the answer to, because then I know if somebody's lying and I can prove it, or they're confirming what I already knew. So really, there's no reason. Each one of these interviews probably is between 45 minutes and an hour. And you're just going through sort of meticulously, what do you normally do and what did you do on that day? All right, James Jackson, the principal. Principal had the money handed into him the next day, or was going to, and it was $25 short. What are we going to ask Mr. Jackson? I know I only gave you 5 minutes. Anyone?
Well, the one question we came up with is who has access,
Mhm.
the keys to that desk? If the
Absolutely.
Have you checked video?
Did the principal check the video? Sure. Well, first of all, we don't know, did Mr. Smith come to Mr. Jackson at all and say that the money was missing? Right? Or did he come to you first? I didn't give you that information, certainly, but yeah, did you check the video? What have you heard? And I didn't tell you where this desk drawer was, but if the desk drawer is in the principal's office, who has access to it, and depending on how the other ones went, what do we know about Mr. Anderson? What do we know about Mr. Smith? So I have just a question. I didn't want to send it to you in breakouts, but in this, what are some of the outcomes? What do you think? I got to 3, I think, but what are the possible outcomes of this? 4. What are the possible outcomes of this investigation based on the questions that you've asked, and what do you might ask, and what do you think those are? What do you think you might find out?
We could find out we may not have policies in place that we need to secure money.
There are 5 possible outcomes. Thank you. Yes, I hadn't thought of that, but absolutely. You might find out you need some policy or some processes.
Yeah, termination.
Of who?
Well, depending on what you find out in your investigation, if you actually see somebody walk out with, in the videos, or you can come up with evidence, there might be a termination that will result.
Absolutely.
Legal charges.
Yeah, and I guess those are certainly outcomes. I was thinking more of the fact-finding part. So what I was thinking, we could find out who took the money, or if the money was ever gone in the first place, or if, what I came up with was a mistake. Jack Anderson, the night custodian, took the money. The principal took the money, or Mr. Smith took the money himself and, knew he was busted, so he came to complain about it first. Or I guess 6 now, because somebody else entirely you could have found out. So it's a mistake, or somebody took the money just doesn't disappear. I know in some cases like this, where it became apparent that money wasn't making it where it had to be, I'm aware of at least one of my clients that this was years and years ago again, that they let it go once or twice to change the procedures and mix up who was involved because they had a suspect they were kind of, zooming in on. And it ended up being a very elaborate investigation where I think it ended up being either the superintendent or a business manager or somebody, standing there counting every dollar, taking a picture of every dollar, or 5 or 20 or whatever, the night that it was counted, handed back to the employee that they thought was stealing the money. I think the picture was taken surreptitiously after the employee left, if I recall. And then, doing it all again the next morning and seeing what happened. And, again, this was more than $25 once. This was, a few $100s a few times a month kind of deal. Big ticket items, big football games, not the riotous chess club match I've been making fun of. But you might want to do something like that, but it could very well be a mistake. It may result in criminal charges. It may result in you buying a security camera and not telling anybody you've installed it. I mean, all of these things are possible outcomes. And I picked a littler thing to compare to the other investigation that we're talking about here. But it's it's something to bear in mind. And I think the questions you came up with were great. I think those steps were all great. As even if it is a smaller thing, is kind of slow down and make sure we really hammer in absolutely everything else. So other than interviews, just sort of moving on to other things you might be looking at, other investigative techniques the school might use. Observation, right? You might have been there. You might have seen the fight in the lunchroom. You might see somebody go into a locker room or come out of a bathroom. You might look at surveillance video, certainly, if you have it. There may be, in some cases, a scientific method. I've hired handwriting experts for purposes of a HR investigation before, because the person was alleged to have fraudulently changed a reimbursement or a paycheck or something. I don't remember exact details, but we went and had a handwriting expert look at it. You might want to get a voice expert if the situation calls for it. Now, I'm not saying you do this every time. This isn't every investigation, but it's an option that's out there if it's necessary. And you don't really need to be an expert. If somebody's handwriting doesn't look anything like their handwriting, you've all seen forged permission slips and things like that, unless, 90s sitcoms were lying to me, and children don't really do that. But, you know what you're looking for. History is a great thing to keep in mind. We're not going to, say that somebody's guilty or not guilty based on their history. Oh, they're a good kid. But you want to look at the specific history. Do Billy and Susie have a history of dating? And so maybe it's not an assault with that, and that Title IX's its whole thing. But do they have a history of fighting each other? Do they have a history of, they used to be step siblings and their parents got divorced and now they hate each other? I mean, is there a history there? Is there a history with the employee? This employee has made bad jokes before. This employee has got a hot temper. These all are just things you might want to look at. And then, of course, electronic data. And to the extent that it's your email server, you can pull your emails, right? Without any real privacy concern. You want to make sure you have a policy in place that says you can do that. I'm sure it's in your acceptable use policy. But you want to look at the emails. Are there text messages on a district issued phone? Are there voicemails, left in your system that you can listen to? Or are there somewhere else that somebody's going to give it to you? So a word about that. Oh, well, it's just my picture of a surveillance camera, I guess. A little late. Oh, shoot. I had something about preserving electronic evidence. You want to make sure that you're preserving electronic evidence, and not just the chain of custody like the police would do, but you want to make sure that you secure a computer. If there is, physically remove it from the employee. If there's an allegation they did something with the computer, take it from the employee or their work area, make them turn it in. Disable a password if you need to, either a student or an employee. And I'm picking on employees for this part, but it could be students too. If going back to our hypothetical, if you think that Mary posted something inappropriate from your district issued tablet, then you want to grab, physically get the tablet so that you can see if she logged into Facebook, and you can do whatever you need to do on that. You only want to let somebody who knows what they're doing around accessing the computer. You might want to hire an outside forensic investigator if you need to. Again, if you need to, but you don't want me to be poking around the computer. I can't tell you what metadata is. I, darn near broke my headset a minute ago. You don't want me messing around with computer. And since we have a minute, there's a man named Phil I blame for this. I used to be okay with computers, but Phil is a computer engineer, absolute genius. And I lived with Phil in college, and he just fixed all my computers for me all the time. And so I never had to learn anything past what computers were like in college. But anyway, which did not look like they look like today, that's for sure. But in any event, only somebody who knows what they're doing should be poking around with this stuff, because there is some potential liability if you go too far and access like a personal social media account or something, and I'll get into that. But you also want to be able to say, if the forensics of the investigation, we restored these deleted emails, who did it? Well, is it so easy that you can just hit a button to bring them back, or did you actually have to dig in and have your IT guy do it? But you also want to make sure that you are turning off auto deletion. That's a big one. Your email servers don't store indefinite amounts of email. You purge every once in a while. Same thing with surveillance video. It gets rewritten or purged, assuming it's electronic and not the cool old tape kind. But even that you'd be rewriting, respooling it every once in a while. So if there's something that you become aware of, grab it before it's deleted and gone and you can't get it back. And chain of custody, again, you want to be able to identify everyone who's touched the computer from the time it was removed from an employee or a student until now. So somebody can't say, oh, you logged into my account and you sent this so it looked like it came from me. Well, here's everybody that's touched it. It's been locked up in that desk where, Mr. Smith kept that money the whole time. And we actually know who has the keys now. All right, before searching any computer, make sure that your policy says you can. It's your computer. You probably does say you can as a district, but you want to make sure that it's your sole property and that any data stored is, subject to monitoring without notice. That just defeats the later invasion of privacy claim or the expectation of privacy or an illegal search and seizure kind of claim. And it's very interesting. People seem to forget that sometimes. And I had one unfortunate and one unfortunate for a different reason case. I had one unfortunate teacher who inadvertently synced their classroom iPad with a personal account and had taken some, what I've given to believe, I did not see them, risque pregnancy pictures that were just for her and her husband, but they were linked to the iPad that the 6th or 8th graders, the middle school anyway, boys used in class, and gosh, it just popped right open. Accidental, but you want to make sure that you're not inadvertently logging in. So that's why I say let only people who know what they're doing handle these devices. But also, since it was now on this iPad, it was discoverable for the school. And then somebody who received and sent risque messages to their boyfriend from their email account at school and then forgot about, this was a teacher again, forgot about it, left it open when they linked their computer with either a smart board or a smart projector or something. And weren't pictures, but these kids were old enough to read. Yeah, that didn't work out well. So technology is a double-edged sword, but you want to be able to have a school email account. So no, I never sent anything like that. Okay. Here's the email. Yes, you did. I have the email from your account. Now, people tend to be a little more sophisticated and only send things from their personal Gmail or Yahoo or Hotmail or whatever, but not always. And you can also tell when that was accessed. Even if I can't prove that you sent a dirty message from your Hotmail account, I have an acceptable use policy that says you won't be sending Hotmail messages, personal messages during class, and I have you doing that, or I have you on, 37 websites. Or I mentioned earlier the investigation to an employee who was alleged to be on dating websites, adult dating websites. That employee ran afoul of the acceptable use policy because the employee had managed to set up like a VPN. It wasn't called that because this was, more than 10 years ago. It was something different, but, a virtual desktop to their own computer, and were able to, avoid all of our firewalls and scrubbers and things like that. So don't know if this person ever was on the adult dating websites. Do know that they violated the acceptable use policy by doing that and trying to get around things that would prevent them from being on these adult dating websites. Anyway, all right. Another hot topic is coordination with law enforcement. Big ticket items we're talking about here. This isn't cheating. This isn't, Billy pushing Susie on the slide. This is, assaults and drug sales and all that nasty stuff. All right. First, I said report everything to the police. Report, not everything, sorry, back off. Report suspected crimes to the police, absolutely. But you want to make sure you conduct your investigation, because you might have to go down the same road. Title IX, for example, requires that you get going. You can't wait for the police. You want to make sure that you're conducting your investigation in a manner that you don't interfere with their investigation, either intentionally or unintentionally. You don't spoil the evidence or disturb the evidence that law enforcement would need to gather. Your police won't thank you for that. And, I've had police, say things like, well, it's, interference, obstruction of justice if you do your own investigation. No, it's not. We might have to talk to the city attorney or the county, the district attorney, whoever. But we need to go through and do our own thing. But preserving the evidence, we'll turn it over to law enforcement. Is a subpoena necessary? Maybe, depends if it's FERPA, that kind of thing. FERPA doesn't say that police get access to everything just because they ask for it. FERPA says that with a subpoena or a court order, and by the way, a search warrant is a court order, that they can have access to things as long as you follow certain processes. And I know it's the easiest thing in the world to say to your law enforcement that you rely on too in your community. I know that, to say, here you go. It's a violation of a federal law if it's FERPA data. And it's one of those ounce of prevention kind of situations. You might want to explain it before just saying no. But in any event, if you do go down that road. So that's sort of 2 cents on that. I would say I don't rely on an outside law enforcement investigation for several reasons. First, you might never find out about it. Police have their own rule about what they can tell you, especially if it involves a minor. Second, you might get different degree of sophistication from one case to the next, one officer to the next, one town to the next, whatever it is. But more importantly than that, you don't have any control over it. You can't do your own witness assessment, or, unless they let you sit in which case you're really doing your own parallel investigation. You don't hear it. You can't make those firsthand determinations. Again, they might not give you all the information because either they don't want to or they can't more often than not. And then also, finally, the police operate under a different standard than a school district does. The police are looking for evidence to say that something happened beyond to convince a jury that it happened beyond a reasonable doubt. That's not the standard. Most of the time you're operating under a preponderance of the evidence standard, unless you've adopted a higher standard in a policy or something, but 9 times out of 10, it's preponderance of the evidence. I say 99 of 100. And that just means it's more likely than not. The police may say this can't prove it, but you can't prove it beyond a shadow of a doubt is way different than saying it's preponderance of the evidence. I know a lot of times in, it's he said, she said, we don't have enough to go forward with this. That's the end of it. Okay, that's the end of it. If you're going to take this to a criminal trial, certainly. It's not the end of it if it's a required Title IX investigation, or it's not the end of it if it's an investigation you have to conduct. All right. Social media and investigations, just very quickly, constitutional limits on student searches. You can search students' possessions or belongings only if you have a, quote, reasonable suspicion that the search will yield evidence that a school rule or law has or soon will be violated. The search has to be reasonably related to in scope, rather, the circumstances justifying the search. In other words, and this is a quote, the search must be reasonably expected to produce evidence of the violation of the school rule or law. So the search has to be reasonable. You have to have a reasonable suspicion. That's lesser standard than probable cause, but a reasonable suspicion that your school rule has been violated, and the search itself has to be reasonable. A few things, a strip search, for example, is rarely, if ever, reasonable and opens you up to all kinds of questions. So I don't recommend it. Searching a student's bag, might be reasonable. What are you looking for? If you think the student has a rifle, why are you asking to look in their little mini purse, right? It's not in there. Now, if if it's a gun or it's a knife or it's drugs or something that might fit in that little bag, sure. But, somebody's walking around with a shotgun or a rifle, that's not going to fit in the purse, the backpack. So This also applies to looking at smartphones and public social media. I don't recommend ever making someone go into their social media account. There's cases out there on it. Log in and show me. You know, they have a right to some privacy, and don't have the ability to do searches like that electronically, possibly without a warrant. Certainly not. Just not doing it just because the school said so. Now, that being said, if somebody is friends, and I'm not saying that you should have like a sleeper agent go in and make friends with all the students and staff, but if somebody has a friend who gives it to you, for example, Jane's mom in our first hypothetical, that's fine. You can certainly take that. It's not unlawfully, accessed or anything, but forcing them to log in is the problem. All right. One more thing on electronic things, and I see people are dropping off, and I'm sorry, I probably should have led with this. This is the most important part of the presentation. Do not retain copies of actual or suspected child pornography. And you know what? That's the second most important thing. The most important thing is do not send me copies of actual or suspected child pornography. One, you're sending it across state lines. I'm not sure if that makes it a federal offense or not. Two, it's a felony here in Minnesota, and I presume in North Dakota as well. I don't want it. I don't have an exception to have it. You don't have an exception to have it, probably. Only the police have an exception to have it, and prosecuting attorneys. If you are doing a sexting investigation or something, because there's people are sending pictures around, you don't want to back up the copies to your own personal computer. You don't want to take a picture with your own phone to store it later for the investigation. There is a case out of Virginia from 2008, State v. Ting Yi Oi. He was a high school assistant principal in Virginia who was charged with possession and distribution of child pornography and failure to report child abuse because he mishandled the sexting investigation. He backed up the images. He had the student send the images to his own personal email, by the way. And it was for the investigation, he said, which may have been true. He eventually was cleared of all charges. If you look this guy up, and he made a circuit of talk shows some years later, explaining how his life had gotten ruined by this kind of thing. But okay, eventually cleared of all charges is not the same thing as, was able to be an assistant principal in this town in Virginia anymore, or, kept his teaching license and things like that. So really, if you have any questions about that, that's a call to law enforcement or your prosecuting attorney in the area. What do I do with this thing? Okay, we got about 10 minutes left. I want to talk about Title IX very quickly. Sexual harassment under Title IX is conduct that is, that is based on sex, which includes gender expression and identity according to the Office for Civil Rights. It's not in the statute. Supreme Court hasn't ruled on it, but according to the Office for Civil Rights, was the organization that enforces Title IX. It includes gender expression, identity, and sexual orientation. So the conduct is based on sex, and it must meet one of these three things. Either a school employee conditions receipt of a benefit or participating in unwelcome sexual conduct. That's the you give me an A if you go out with me kind of thing. Or two, the unwelcome conduct is determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity. That can be one incident, and the one that I use in my hypotheticals, so I guess I'll use today, is if I call somebody a particularly nasty gender slur, or out them as gay, or or something like that during, an all-school assembly, or I managed to rig the bleachers to show the scoreboard to show their private naked pictures or whatever, things like that. One incident, severe, pervasive, and objectively offensive, that'll reach the conduct level. Or anything that would classify as sexual assault, dating violence, domestic violence, or stalking as defined in federal law. You kind of know what those are without even knowing what the definition of federal law is. There may be some questions, but I don't want to go through the definitions here. But for investigators have to be independent, and that's a word under Title IX. Independent investigator has to be a neutral party with no conflict of interest or bias against either the complainant or the respondent, or complainants and respondents in general. So one way to be a neutral investigator, you can't, if you are the principal, but you've always hated this kid, or the parents say that, you may be biased, or you never find in favor of girls for whatever reason. Maybe you want to sit this one out, things like that. There is a presumption under Title IX that the person who's accused of doing the alleged act is not, quote, responsible. That's the word Title IX uses. That the respondent is presumed to be not responsible, rather, until the school shows by a preponderance of the evidence that that it happened. The school investigator has to decide. It's not up to either party to present evidence. The complainant doesn't have the burden. The respondent doesn't have the burden. The school has to get there. So 50.0001% or 51%, however you want to think about it, more likely than not, preponderance of the evidence that the person is responsible. And that's what the investigator needs to sort of be thinking through. There's different information that you might get in a Title IX investigation. You might not get in other investigation. Privileged information, particularly medically privileged information, medical records. I mentioned Title IX has its own data privacy rules. The Office for Civil Rights, it's in their regulations now that the people who you have to disclose records to under Title IX, that takes precedence under FERPA. So normally I wouldn't say that I investigated, Mary or Jane or whatever. If I'm doing a Title IX investigation, when it's time to send the report around, it goes to Mary and Jane. So I have several other things here about Title IX investigations. You can consolidate complaints. Parties have to get an equal opportunity. There are required notices. There's required investigation reports. There's stuff in the materials about how to write a good investigation report and what relevance looks like. I mentioned earlier I have a hard time to stop talking, but I only have 5 minutes left, and I'd like to answer any questions if you had them. Otherwise, I can tell you one humorous war story about a poorly written Title IX investigation report, but I'd like to hear some questions if you have them. All right. Well, as one thought exercise, I skipped through it to get to the questions slide. Going back to that first hypothetical, if you care to think about what we talked about in any greater detail today, think about that first hypothetical with Mary Smith's social media post. I'm sorry, Mary's social media post. And we got Joan Smith coming to show the Facebook page. We got the I Hate Mr. Johnson. He's an a-hole. He's only nice to Jane because she's hooking up with him. Those pictures Bill showed me are gross because she's so fat. I should shoot them both, etc. How would you, assuming that the Title IX requirements are met, that you have a formal complaint, let's assume that Jane filed a complaint against Mary for calling her fat online and saying she wanted to shoot her, but it's not a Title IX complaint. But there's no formal complaint against Bill or the now named other teacher, Mr. Jones, who weighed in on telling Mary it was inappropriate. How would you do that investigation from start to finish? And we don't have time to go through that right now. And I won't send you breakout sessions just to say goodbye. But if you want to stop and think about it, what would you do in this situation? Would you farm some of it out to an external investigator? Some of it, all of it? Which ones would you prioritize all the way through? What kinds of questions would you ask? It's not a very pleasant thought exercise, to be honest, but I think it's a useful one to think about. Because frankly, if you can get through that hypo, I think you can get through just about anything that school throws at you. I mean, I've seen worse, but not much. So with that, I do have one last humorous war story, unless somebody shuts me up. One of my tips for writing a good investigation report is to write professionally, and both in terms of quantity or quality rather, and in what you say. I was helping a school with a Title IX investigation, and their investigator wrote a report that, God, this was years ago, it was before the new Title IX regulations. Anyway, it was involved gender slurs and sort of some nasty sexual language, as they tend to do. And the investigator didn't use quotes. The investigator just said, student A's, and the adjective was luscious, and I won't provide the noun. Student A's luscious noun, and it wasn't in quotes. And I had to stop and mention this to the dean, saying, it looks like you're saying that. It looks like you are referring to one of your students as luscious. I know you're not. Put it in quotes. Take a minute and edit it, because this goes to people, either in litigation or now under Title IX. It goes to them just by virtue of the process, and you don't want that attributed to you, or you're on the first train out of here, really. So, just again, take a minute. Editing is key. Documentation is key. We have 2 minutes left. Is there anything anyone wants to add or ask? All right. Well, for everyone watching the recording, I'm sorry I wasn't able to answer your question, but I am just a recording. For everyone who is here, we'll call it live virtually. Thank you today for listening to me for the last 3 hours and putting up with my war stories and my technological issues. And thank you to Russ and Amy for having me, certainly. Look forward to seeing you all in person at one of these things sometime.
Thank you.
Thank
All
you.
right, sounds good. Thank you, Christian. We'll see you tomorrow. I think most of you guys are signed up for tomorrow as well. Just a reminder, we'll start right at 9 o'clock or Central Time. I see Dr. Peters there, so Mountain Time went in my head. 9 o'clock Central Time.
7 hours of my jokes and war stories. You guys are gluttons for punishment, but I will see you there.
Thanks, guys.
All right. Good night. Or goodbye for those of you watching it time lapsed.